Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Ricada of Ricada Law, a small law firm in central Minnesota. Apparently, the Black Plague has come for this town. Why do I have these on? I don't need these on yet. I am exhausted. I wasn't so tired earlier today. I felt great. I was like, oh, let's do the nighttime show. We'll get this thing moving. We'll get through this. We'll get this Rittenhouse hearing and all that shit. We'll get everything. We'll be awesome. Yeah, that's great. And then as the show approached and I made dinner and had to go up and downstairs a couple times. God, I feel just absolutely pathetic. It's great. It's phenomenal. I strongly recommend that everybody get this cool disease, and then they can all be exhausted or whatever or not. It affects people so differently. So I guess it doesn't, it doesn't matter. But anyway, loaded up on some Dayquil. And so once that kicks in again, the coughing will reduce and we'll be good to go. We'll be good to go. What else do I want to say? What else? Drink some 5-hour energy drink? That's disgusting. That is horrifying. I did have Sargon on earlier today. It was a great chat. Really enjoyed chatting with him. Such a interesting guy who has been through so much of the internet, right? To go from Gamergate Sargon posting videos about Anita Sarkeesian, Zoe Quinn, feminism, to Killstream Sargon, getting in the muck with weirdos like Ethan Ralph and Medicare and Andy Worski and stuff like that, on to now, the refined political commentator and host of the podcast of the Lotus Eaters. It's an interesting progression through this internet sphere, and so I think he's got a lot of valuable insight on all that. But anyway, so I very much enjoyed that conversation. I hope you guys did too. And if you missed it, make sure and catch the replay of it when you can. That being said, tonight we are on a quest to get back to this Kyle Rittenhouse story, this hearing. We're gonna listen to the Doe Bear hearing and see what comes of that. Trying to think if there's anything else we need to preface before we get into it. We might get around to talking about the keyword warrants. Keyword warrants are this thing that the FBI apparently does with search engines, right? And with internet, with, I'm going to say internet service providers, but I don't mean like Spectrum Internet. I mean internet services providers like Google, search engines being one of them, but it's not limited to just search engines, where basically they can request data on anybody who did a search for a particular keyword. I wrote about this type of stuff, not this specific issue, but this type of stuff as my final paper in law school, and it's the death of your privacy rights in the digital age. You don't have any. You don't have any anymore. They're gone. And we've given them away to private companies. And this all started, with a humble a humble Supreme Court decision years and years ago, and they used it to go after people using banks, right? Like normal people do. They use banks. Well, criminals use banks too. And so what they started to do was to make they started to request from the banks information about people who banked with the banks, right? Like, so they just said, hey, we need you to turn over your business records about this person. And then they didn't need the same level of probable cause. It wasn't an invasion of privacy, it turns out, because, you know, you told the bank who you wrote a check to, so therefore it wasn't private ever. Yeah, that's how that went. So since you wrote a check, then that means you included the bank in your transaction, and the bank is able to keep that record as a business record, logically, right? They need to keep track of where the money goes. And so therefore, the government has a right to see that, and you don't have any privacy interest in it at all. I mean, despite the fact that, like, when your bank gets hacked and someone sees your banking transactions without your authorization, it's a fucking crime. But, you know, if the government does it, it's not a crime, and therefore it is good and right. And that's the logic that the Supreme Court started with. And it's this idea that third-party business records are therefore are not protected under the Fourth Amendment. The way that everything else that you have is protected under the Fourth Amendment, but not if you share it with a third party. This extended, of course, to phone companies, and not to the conversations that you had on the phone, because that would be a bridge too far. But and the phone company has no business interest in recording every conversation that you have through their service. But they do have a business interest in recording every single phone number you dial, or every number that dials you, right? Because they operate the switchboards. They need to know how much traffic is going where. And especially when you're thinking about, there were literal switchboards at the time that this happened, and there's someone, you know, plugging in the different wires to connect you. They reasoned that the phone company, you know, has a business interest in keeping track of all these numbers. And so therefore the government had a right to figure out every single person you've ever called, or who has ever called you, and determining what they will from that. And you don't have a privacy interest in that at all. And this backwards line of thinking has gone haywire in recent decades. When I finished law school, the key case that I focused on that paper was United States versus Jones from 2012, I believe. There's a lot of US v. Joneses. This one was from 2012, and excuse me, it involved a GPS unit being slapped on the outside of a car. It was a decision written by Justice Scalia, and it's one of his worst decisions, in my opinion. He reasoned that the GPS was a breach of privacy, the GPS unit, but only because they installed it outside of the warrant timeline, and that it was a trespass to this guy's property right in his car. That was what was violated in his case, was they trespassed his property rights in the car itself. But Scalia basically says that it's just fine that the government was tracking him all across everywhere he went, that this GPS tracking was okay. Even without a warrant, the GPS tracking is fine because he was on public roads. And to me, that doesn't make sense. Like, that doesn't jive, right? Like, the idea that the government can follow all of your movements digitally without a warrant is okay, so long as they don't attach something to your car outside of the scope of the warrant. And as we know, they no longer need to do that, right? There are cameras around town that take pictures of your license plate, and they can put They can take those cameras, and because you're on a public road, they can track your movements through an entire city with timestamps, and track the license plate of your car. And there's nothing you could do because, well, you're on a public road, bro. It's public, bro. So it's fine. This is the surrender of rights in the digital age. And these keyword warrants are just an extension of that. It's the same principle, right? Google needs to know what people are searching for. They keep records of what people are searching for. It's a proper business record for a search engine that they keep track of what's being searched, in what states, where the traffic is going, what it's doing. It helps them to algorithmically build better search results or whatever, right? Whatever excuse they need. They don't have to have a good one. They don't need to have a good excuse for it. They just need to have an excuse, a business excuse. So they keep all the data because data is cheap to store. They can store exabytes of data pretty inexpensively relative to the scope of Google as an operation. And so because of that, the government doesn't need to go to your computer and invade your privacy, right? Like forcing you to turn over your search terms. They just go to Google and they say, we think we know who did this stuff. We think we've got a hunch, and we're pretty sure what they searched for. So we just go ahead and ask Google, turn over the info on everybody who searched. And then it's this cool confirmation bias, right? Well, look, we knew that guy would search for that thing. Therefore, he did it. Done. Signed, sealed, delivered. It's a shit deal, but it's not surprising. It's not a surprising thing if you've been following how digital surveillance works. And digital surveillance now just works fully complicit with the third-party companies. And there is no escape. There is no escape from it. There's nothing you can do to protect yourself from it. There is no legal remedy for it. There's no court that'll save us from it. There's no rule or amendment or anything that is presently even a glimmer in someone's eye to stop this. Because the Supreme Court has long held that once you give data to a third party, it is no longer private. It is the worst. It is one of the worst long-standing decisions that there is, in my opinion, and it's justified by criminals, right? Criminals. But the people who did it were bad, and therefore, the people who did it are bad. We're now justified in putting the bad guys away because we want to stop the bad people. So, I don't know how much time I want to spend talking about the keyword warrants. I think I've explained what they are. Literally, like, let's say Google's like, or let's say the police believe that there's a guy who's out there killing kittens, right, in a neighborhood or whatever. So they just ask Google for everybody who looks up kitten crushing videos or something. And they give them a list of keywords, and then they give them a list of users that has searched for that. So that's how they work. And they're just the logical extension of this idea that you have no privacy because private companies are third parties, and no matter how much privacy you think you have, no matter how much privacy they swear to give you. Like, I don't know, I talked about this once or twice, but Proton Mail turned over a bunch of IP addresses and stuff to the French government, I believe. There is no safe company. There is no safe company at all. There's no safe third party. They will all cuck to the government for you. All of them eventually will. They just need an excuse. They just need an excuse. And the government needs enough of a reason to threaten them. And then they'll all of them will cuck to the government. That's just how it goes. So I don't know what else to say about it. I wanted to touch on the subject because I know people are talking about it. There's it's gone. It's gone. Your right to privacy is gone. If you want things done in private, you literally have to do them in private. And fuck if I know how that even works anymore. Good Lord. Looks like we need to learn how to set up our own personal email servers. Maybe. What we have to do at the end of the day, the only thing that's going to work is to decentralize everything. Decentralize everything, distributed networks, buzzwords, technology that I don't understand is the only way, where the data isn't anywhere. Right? That's the way this is going to work. And in the meanwhile, until we have everything distributed to where the data isn't in any one place, that it's spread out across the entire user base of the globe, so that portions of your email are in like Kazakhstan and New Guinea or whatever. Until that happens, there will be no privacy or security. As long as the feds have a place to ask, then they will be able to ask, and that place will capitulate. I know there are people working on it. I know there are people working on that, but it'll be a matter of getting everyone to adopt it. And the hardest part is going to be breaking the monopolistic social media and big tech companies who currently control the data, because it's valuable to them, right? Like that's where they make their money, is on the data itself. And so how do you convince Google to not own it? How do you convince Facebook to not own your posts and your data and your messages? How do you convince them to do that? I don't know. But at some point it'll happen. I don't know if it'll be while we're alive though. You know, that seems like a big project. It'll sure be interesting. Okay, there's a couple chats before we get started, and then we'll go. I'm gonna see how long I can hold out tonight. I am feeling rough. I feel good. I'm just tired now. I don't feel particularly sick. I got the lingering cough, and I've got this fucking lump in my lungs still. Who knows? That's probably going to be there for a month. Wolfgang Deo says, bro, I dodged a bullet with OUAZ, my university. They actually were implementing the vax mandate right when that professor went tyrant insane. Lol. Mario Carter says, keyword warrant equals government Google alerts. How embarrassing. Xenobit says, Nick, would you review the video Fatsplaining the Web Part 2 featuring Ethan Ralph? I'd rather not. I'd rather not do that. I don't really have any interest in talking about Ethan Ralph. And let me clarify this. I've said this so much over the past year, but I don't think people believe me. There is nothing less interesting on earth than a fat Virginian yelling at people on the internet, to me. I have never cared to be to follow the antics of Ethan Ralph. He's boring. He's just a dummy who commentates on things like everybody else, right? And I know a dummy who commentates on things on the internet. Me. I don't need to follow some other dummy. So I'm not really interested in talking about Ethan Ralph. I did my talk with Josh. We talked about what has happened, and I consider that my speech on it. If he were to fade into obscurity tomorrow, that would be one day too late. And if I could never talk about Ethan Ralph again, I'd be extremely, extremely happy to do so. And I think the world would be a better place. Ed says, don't order anything out of Colorado. My Night Force scope / pistol cleaning kit was pilfered by UPS workers. The shipping company used tamper-evident tape, and it showed up all cut open. Damn. That sucks. But yeah, well, they're probably on the lookout for le drugs, right? Because that's how they do things. It came from Colorado. It must be drugs. Hunter Counts says, I couldn't donate during the Sargon stream, so I am here. Please tell Sargon a super chatter said he needs to stream with Louis Laveau. You should too. I really liked your stream with him. Maybe all three of you stream together. I don't know. We'll have to see. And then what was there? There was one. I know there was a Justice chat that came in. Scott Wolf 14 says, it's my birthday today. Can you shout out my channel in Trump voice? My channel is Scott E. I'm finally getting over the flu. Soon I'll have more videos out on my channel. Thank you, Nick, for helping me be stronger than I could be. Sure. Everyone, you need to go check out this channel on YouTube. It's a neat place, YouTube. Lots of people get to gather around making videos or whatever. This one fella, Scott E, is his channel. Give him a look. I don't know if it's any good. Maybe it's good. Maybe it's bad. You got to be the judge. I can't tell you what to do. So there you go. Check out Scott E. And sorry about the weak impression. I'm not not in tip-top voice shape right now. I don't know why. Don't know what happened. But something did. That's right. It's called Lacoof. Lacoof. Let's see. All right. Let's get this going. Yes. Let me, stupid Space Marine. Space Marine had my cord. Let's see. Here we go. What am I doing? This one. Oh yeah. Perfect. Yay. Okay. Let's Guys, I fucking hate being sick. I just hate it. There's nothing more emasculating than like being undone by a fucking cough. Oh, Jesus Christ. Okay. Here we go. Get some tea, buddy. Yeah, no, it's the problem is this pneumonia. I'm pretty sure I have pneumonia, but I don't want to go. I tried to have a doctor's appointment and they canceled it. And they're like, go to the ER. And I'm like, but I don't want to go to the fucking ER for some pneumonia. I just need, give me an antibiotic. Just give me a goddamn antibiotic. That's all I need. It's all I need is an antibiotic. Jesus Christ. Anyway, go to the fucking ER. Well, what am I? What am I? Am I dying? I'm not dying. I just have a bunch of liquid in one of my lungs. That's where liquid goes, I thought. Oh, yes. The WoW entitled much. That was the weirdest thing. I don't know. Maybe some of you saw that on Twitter. So after my stream yesterday, where I complained that my doctors would not give me any treatment, someone left a big comment about how I used to be cool, but now I'm an entitled influencer asshole because I demand everything for free. And I'm like, what are you talking about? Apparently wanting to get medication for COVID-19 is entitlement. And it's like, I didn't ask for anything for free. I didn't ask for anything other than just let me buy any medicine, just any of it. The whole prescription medicine thing is it's a weird thing in the US. Right? If you think about it, you go, okay, I have sickness. There is drug to fight sickness. In theory, I should just be able to go buy drug to fight sickness. But we do this extra step where we go, well, you have to go to a doctor who is licensed to give the medicine to you. And you're like, well, I mean, okay. So the doctor regulates the distribution of this medicine, which I don't agree with in principle, but I guess the medicine is dangerous. I mean, typically this stuff is way too expensive for people to be just willy-nilly taking it. But okay, so if I accept that premise, what happens then when you have the sickness and you have the doctor, but the doctor won't give you the medicine? And you're like, but now you're not a door, you're a roadblock. Like, there's not a good reason to deny the medicine. It's not like this medicine it's not like I'm buying 800 pounds of heroin. It's like, I just need more fentanyl to give to my friend George Floyd. Like, none of that is happening. This is just, you know, COVID meds and antibiotics. It's anti-fucking biotics. And, but there's now like a block. And it's like, whose idea was this? Why does this system make sense? I don't understand. Like, we shouldn't tolerate this. But we do. There's no changing it. I mean, I guess I could order the drugs from India or whatever, but like, you'd open the bottle and they'd be like, please give me your VIN number so I can sell you car insurance. And you'd be like, fuck, no, you can't get away from it. God damn it. Spriggan 1337. No, I know that antibiotics don't help with viral infections, but the problem with COVID is that you also get secondary infections that are bacterial, like a sinus infection or an ear infection. That's the shit that, if they won't give me the COVID meds, I want the other medicine to treat the bacterial secondary infections. Like, God damn. So anyway, half your pills are from India, Baneling. There was also a vaccine that was offered to lessen said symptoms. Look, I don't get experimental injections, personally, with the promise of lessening symptoms potentially. Like that, there's literally it's specious reasoning to say that I either We know that it doesn't prevent anything. That's the science, because I know people who are vaccinated who got it at the same time I did. So I know it doesn't prevent the thing, and to say that it reduces symptoms, well, the symptoms are so varied between people. Like, some people, it's a sniffle, some people are asymptomatic, and other people get it really bad, way worse, and then some people die. So you can't tell me that things would have been different had I gotten the poke. There's no way to know. And now there's even less reason for me to get it, because I have my natural antibodies now. So anyway, here we go. Let's get back to this Kyle Rittenhouse hearing. Where we left off, they're just about to start the Dober hearing. That is how you qualify expert witnesses. And so they're going to do that with John Black here and Bob. These two guys are going to get Dobered to shit. Even though Bob's expert witness report has not been produced yet, despite the prosecution having well over a year, they have decided, he'll get around to it eventually by the 18th. Bad Vibe says, when do we find out that the prosecutor was tubing during this hearing? Not soon enough. All right, here we go.
John Black, he's appearing remotely.
All right, Dr. Black, would you raise your right hand, please? You solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Go ahead.
Can you go on their television?
It should be on there if you turn it on.
What? Oh.
I think. They didn't, you didn't know what?
Good job, guys.
Defense will call Dr. Black and ask that he be sworn. My understanding that we have a stipulation that Exhibit 1 is Dr. Black's preliminary report and the only report he's done up to this point with the state. That would be Exhibit 1, and that is, I want to get it right for the record, a 29-page report, and that the CV is Exhibit 2, and that, in fact, is a 43-page report.
That's correct. We have a stipulation.
Would you please state your name, spelling your last name for the record?
John Black, B-L-A-C-K.
And Dr. Black, in what state do you reside?
Oregon.
And you're currently appearing remotely via Zoom?
That is correct.
And you prepared a report in the matter of State versus Kyle Rittenhouse, dated July 31st.
The man looks like a cartoon. Like, I don't know what camera he has. I don't know how you look like this. I've never seen this look. Like, I know he's got Zoom doing the background blur for him or whatever, but I have never seen this weird artifacty look from a webcam. I don't know what shitty camera setup he has that produces that. It's so weird.
2021, which has been marked Exhibit 1, correct?
That is correct.
And you provided myself back in July of 2021 a 43-page CV regarding your qualifications, training, and expertise. Is that a fair statement?
Yes, it was an appendix to the opinion itself.
And Doctor, what education do you have after high school? Briefly.
None. Just say none.
Do you want both what we would call formal education and police education, or do you want them separately?
First, the formal education, sir.
Formal education, I have a bachelor's in just general science. I took that while serving in the military. After that, my master's was in counterterrorism. After that, I pursued a doctorate, first starting out in Walden University, in the combination of cognitive science and public policy, how people move from a planning stage into a decision. I found out that that's a lot more problematic than it sounds when trying to study, because you have the cognitive scientists and you have that. So I then went over to Capella University into the School of Business, where they allowed me to pursue the same problem, just in a different environment. And that was, how do people make sense of information and then move it into decisions? I received my doctorate from Capella ultimately.
And when did you receive your doctorate?
I think the award was 2018, if I'm correct.
And what was your dissertation?
He's only been a doctor for 3 years. Who is this scrub?
The dissertation specifically was critical thinking as applied to the use of visual information as it then precedes decision making.
Now, what kind of real world training do you have, either in police science or military?
Yeah, so in the state of Oregon, I went up and through the different academy commonly related to as the Department of Public Safety Standards and Training, all the way up to command level, executive level, leadership type training. During that entire time, I both taught and instructed and received anything that would normally be associated with a police officer in the state of Oregon for 23 years. Additionally, in the military, my background is primarily in special operations. I did 30 plus years in the military. I was on what they would call the dynamic side. I was on a special forces A team for many, many years. Did many different things that you would commonly relate to that. But
I did many different things to many different people. Things you wouldn't believe. Things you couldn't understand. I have over 400 confirmed kills.
In addition to that, I also did psychological operations, which again is how people think and influencing people. And I also did civil affairs, which is nation building and anything from different cultures to that, to include even training people in civilians in other countries about self-defense, police tactics, or these type of things. During the time, I also taught civilian academies, these type of things. Since then, and also in police, I've
Remember, he's summarizing a 46-page resume. 46 pages of qualifications, which is a bit much.
act as a consultant instructor, but also personally attend training. I'm an advanced force science specialist as an analyst. I hold examiner certification by Input ACE, which is video forensic, to understand the use of video specifically. I use that in understanding my analysis on use of force. Cognitive interviewing. I mean, it's all my CV, but just that's a quick overview.
You know, the more he talks, the more I'm noticing that his mouth is crooked, and his super bushy goatee doesn't do him any favors on it. But at the end of the day, the relevant part of his expertise here is his doctorate. His doctorate is in processing visual information and making decisions. That's what he's going to be talking about. What did Kyle perceive that made him make those decisions, and why? And that's really the key. I mean, his military background, special forces, right? That's gonna, I guess that'll pad nicely and say, you know, he's maybe been in situations where he had to make decisions in the heat of the moment or the heat of combat or something like that. But really, like that isn't that isn't an actual qualification. Lots of people have had to make decisions in the heat of the moment. That doesn't make them an expert in decision making. That's his doctorate is right on point, which is, of course, that's what you want in an expert witness.
And I'm just trying to hit some of the highlights. Are you trained in the use of firearms and the proper handling of firearms?
Not only am I trained, anything up from what they would normally refer to as a pistol up to a long gun, and then even extended range weapons out to miles for artillery. I also.
I'm sorry. What? Out to miles for artillery. Stop it.
I'm a certified instructor in the same.
And you mentioned that you are, and I'll probably say it wrong, ACE certified in video review?
Yeah, so Input ACE, which is Occam Video Solutions, a type of proprietary software in the review of video, offers both what they call an operator level course, how to use their software, and an examiner level course, which is how to use it in understanding what you're looking at, content. And I'm certified, or I've received a certification at both the operator level and the examiner level. And the final.
I hope you understand. I'm expert certified at looking at video. Oh, well, Jesus Christ, so am I. I watch YouTube all day. I mean, that at some point, it's all bullshit, right? Like at some point, like, I have a certification in watching a video and understanding what happened on the video. Oh, well, la-di fucking da. The rest of us rubes out here just look at videos and can't figure out what the fuck's going on. It's just too many pixels. I don't know. Jesus Christ.
Final one, which I still have another course to complete, is a metrological level, which is the idea of light boards, a bunch of technical stuff that I'm not going to go into. And I'm about halfway through on that.
Have you ever testified in a court of law in either state or federal court as an expert?
Multiple times.
Have you, I should have asked it the other way, but can you put a ballpark number on the amount of times you've testified in a courtroom?
Yeah, so the short answer is I've consulted about maybe 60 times on use of force type cases. Out of those, I've written opinions 32 times and testified 20, plus or minus a couple.
So many times you're engaged in a case where you don't end up testifying. Is that a fair way of characterizing that?
Yeah, I mean, I'll write an opinion, and a lot of times settling by mediation or arbitration, a settlement is reached, or it's dismissed after the opinion's rendered.
And
Ooh.
you were engaged in this case by myself to review the actions of Kyle Rittenhouse, a citizen, on August 25th, 2020 in Kenosha, Wisconsin. Is that a fair statement?
Yes, sir.
And do you look at cases involving a citizen differently than a law enforcement officer?
To a degree, to the state's argument of being put forth, the idea that I look at a lot of things from a police perspective, meaning the laws, the standards, as already been described. That's absolutely true. But the thing that even precedes that is all cops are humans. And so the fact is, the first thing we have to look at when we're engaged in these types of analysis or reviews is how is the human being involved, especially with the affect of their perception, attention, training, put in all the different variables. How is the human interacting with the event that's unfolding in front of them? So I would argue that first and foremost, every person involved in a use of force event is first and foremost a person, and that the principles outlined, in my opinion, are primarily directed towards that. So that's the first part, even if I were to look at police. And then, as the state accurately describes, if there's another layer to apply against the analysis or the reasoning, such as police standards, those type of things, I would then apply those as well.
And when you reviewed this case, primarily you did it through police reports and review of videographic evidence?
Yes, that's correct. A lot of video evidence and breaking that down, and then whatever reports and evidence that were given to me, yes.
Now, in discussing testimony, or strike that, in putting together your testimony, is there anything to consider when making opinions by videographic evidence?
Now, when you say being put forth my testimony, are you speaking to the opinion that I rendered?
Yes.
Okay. Yeah, I think one of the things that's highlighted is video is amazingly powerful. It gives us insight into a lot of things, but it also has limitations. And I've outlined that in the report, and I can use an example right now by what we're looking at. I see a screen right now with potentially, the judge is just showing with his honor's just showing with a phone emblem, but everybody else has mostly pictures up. Every part of this stuff is in the same field of view. I can see everything behind Miss Howell as I can see everything directly in front of Miss Howell with the same degree of clarity. A person, a human being, cannot do that because they're in three-dimensional space. And so you have to begin to understand these things. The value, which I completely agree with, of video, and some of the times the misperceptions of what we're looking at as just a human, and that's just a simple example.
And
Oh, thank you for that very enlightening commentary. Let's translate it into normal people speak. You can see what's behind someone when they can't because there's a video of it. Right? So he's very trained at figuring out what the actual human can actually see. Jesus Christ. This guy sounds like Reddit distilled into a person.
does the video show, in this case, obviously the actions of Mr. Rittenhouse are paramount. Does the video show Mr. Rittenhouse's point of view?
Oh, no, there's no way any video can show a person's point of view. That only exists in the person's mind. And that's where, and just for example, looking at all the different angles of the video, right? At no time do we see what Kyle Rittenhouse was looking at. We see what the camera was looking at, the video is, but we don't see what he was looking at. And even if we did see what he was looking at, that doesn't mean that we can perceive what he was attending to, what made a difference to him, or what he then interpreted from what he attended to. Video is a very good way from a hindsight examination to begin to get an understanding, but video never portrays someone's attention or perception. It's incapable of doing that.
Now, directing your attention to your review of the video and the police reports and information that you relied on, does the circumstances of that evening play any effect or any part in your evaluation?
I would argue yes. I have to take that into consideration because it's context. In other words, as a use of force expert, as a person that analyzes these type of things, everything is sort of painted on the backdrop of context, a canvas, so to speak, to use a metaphor. And in that night, the decision-making that occurred on that evening and that night, the decision-making that occurred by both those people that interacted with Kyle Rittenhouse, as well as Kyle Rittenhouse himself, were on the backdrop of things like riots and crowds and cacophony and noise and all these other type of things preceding violence. All analysis should, or I would argue sound analysis, has to take and affect the context by which it is determined. Something we do here may not be the same thing in another culture and vice versa. So yes, it does have effect.
The fact that there was ongoing chaos or community unrest, that is something you would consider?
I would consider. I wouldn't say it would necessarily make one thing more reasonable or less reasonable than the other, but to not consider it, I think I would be doing an inadequate analysis.
Now, in your review of this matter, you did break down videographic evidence, correct?
Yes, I did.
Now, when you review things videographically for times, is that just using a stopwatch to get the times between first shot, second, third, and fourth shot?
No, and there's two things about this specific case, and this is what I usually do on these. And in the past, I've done them informally, and now I do them formally with a certification. The first thing is video has the ability to be compressed. So even if I was counting frames, for example, 30 frames per second, if I counted 15 frames, I could assume that a half a second had occurred. But video can be compressed. It can be moved around a little bit. So one of the things I did with this case, which I
I mean, video can be compressed, but it still plays back at a given frame rate. Like, there's still 30 frames that play at 30 frames per second, or 24 frames, or 24.9, or whatever. So, like, just because the video is compressed and there might not be 30 frames for a second, it still plays 30 frames. It's just going to repeat some of those frames. It'll just hold a frame every now and then over. Like, what the fuck are you talking about? Like the video, the video playback from the camera, the file itself has a frame rate. You can find it out. It's in the metadata of the file. Okay.
Do with other cases is I also took and applied a piece of sound editing software. But just the short answer is the audio stream, which is uncompressed, is in there as well. And so I validated the timing of the shots by both the videographic information and the audio stream as when the percussion of that sound started down to the 100th of a second.
And using a frame per second calculation, why is that superior than just holding a stopwatch and clicking it off that way?
Oh, yeah. So I used to run track. I used to use stopwatches, and so it's an interesting question. The short answer is, if you think about the stopwatch, it's a perfect reaction. My fault. It's a perfect example of reaction time. I'm waiting for a stimulus. Something's happening on the screen in front of me, and then when that stimulus happens, I transition it to push a button on the stopwatch. Well, that takes time. So by the time I look at the digital display or the analog display of the stopwatch, I've also added in my own reaction time to that as well. Now, arguably, I do that the same way when I look at.
Now, remember, when you're talking to a court, this is why court is so tedious. You are required to treat the court as if it is the dumbest toddler on the planet. That's so, like, making fun of this guy, but this is how you have to do it. You have to lay out why it's better to use the built-in time code on a video to determine the timings rather than literally going click, click, click with a stopwatch. You have to explain that because the court may not understand, which is dumb. Trump Willis is my name, says this guy sounds like the manager in Office Space. So I'm going to need you to come in on Sunday and finish those TPS reports. Yeah. Super Iron Bob says repeated frames change how it's perceived by the eye. It's part of that PhD he's here for. Yeah, but for timing, it doesn't actually matter. If you're using the frames to measure time, then there's still going to be whatever the frame rate is, amount of frames, because that's how video works. Like if the playback is 24 frames a second, no matter how many frames are skipped for compression purposes, the video will still display 24 frames per second. It would just repeat some of the frames where the compression has taken out others. So anyway.
Video and audio, but the difference now is I can go back frame by frame and see a muzzle flash and look down at the recording and have an exact count. Nothing to do with reaction time. I can do that in 2 minutes or I can do that in 2 seconds. It's still the same reading on the screen. So I would argue it's more accurate. And by doing so, I can use a baseline, which gives me a better understanding of what's occurring.
And you broke down the sound and pictures or video for event number 1, which was the 4 shots in Car Source 3 with Mr. Rosenbaum, correct?
Yes, I did.
And those are contained, the times in your report?
Also correct.
And those times would be the first shot is 0?
Is that a question? Yeah, well, it's not the first time is 0. It's that if what I do is I use the first shot as the starting point, so it has a value. I give it a value of 0.
Okay, so the first shot is 0. The second shot would have been 26 hundredths after the first shot. The third shot would have been 25 hundredths after the second shot, and the final or fourth shot would have been 23 hundredths after the third shot, for a total of 74 hundredths from shot 1 to 4. Is that a correct statement from your report?
Yes, sir, it is.
And
4 trigger pulls in less than a second, in 3/4 of a second. Attaboy, Kyle. Bam, bam, bam.
You're dropping out.
Excuse me. You reviewed that and you've used scientifically accepted principles to reach those times?
Okay, sir, just for the accuracy of the court, you did drop out on part of your question. Could you ask the question again?
I did.
Yeah, I'm not
Okay.
from the court. I'm not getting any transmission. If you're hearing me,
Someone forgot to turn the mic on. I can't imagine who that would have been. Try your question again.
Sir, you've reviewed that video and sound stream, and you can provide that opinion to a reasonable degree of scientific certainty based upon your certification as a ACE input operator.
that is correct.
And you also did that for event number 2, correct?
Also true.
And in event number 2, you used the same principles?
Yes, sir.
And in event number 2, shot 1 would have been the 0 beginning of the sequence?
I think I see a lot of confusion in the chat. I want to clear this up before we finish. John Black is the defense's witness. So he is Kyle Rittenhouse's hired expert. He is testifying on behalf of Kyle Rittenhouse. The guy asking the questions right now is Mark Richards, Kyle's lawyer. He gets to open the hearing with examination of John Black. The prosecutor, Binger, will get a chance to cross-examine John Black after Richards is done examining him. So that's where we are. So if people are, I see a lot of confusion in the chat, and so I wanted to make sure. I probably should have cleared that up earlier. This is Kyle's witness, and he is being currently examined by Kyle's lawyer. And so then the prosecutor will cross-examine him after this.
Also correct.
Shot number 2 would have been 68 hundredths after shot number 1?
Correct.
Shot number 3 would have been 1.98 seconds after shot number 2?
Correct.
And shot number 4 would have been, I'm having a hard time reading my handwriting, 2.77 seconds after shot number 2. Is that a fair statement?
That's a fair statement. And I would also point out that we're rounding to some degree. So I would say that all of those measurements are, depending on how a person looks at a frame, I would say the reasonable degree of certainty is plus or minus a hundredth of a second.
For a total of, within the parameters of the test, 5.637 seconds, correct?
Correct.
And that is offered to a reasonable degree of scientific certainty?
Yes, sir, it is.
Now, in your report, you talk about hindsight bias and outcome bias, correct?
Yes, sir, I do.
Could you please give the court an example of hindsight and outcome bias?
Absolutely. So the first thing, just as a walking the walk and talking the talk, and setting the context or the frame, is that I don't use the word bias as something bad. We all have biases. It's not a big deal. We just have to, what happens most of the time is we're just unaware of them. A lot of times a bias may save our life. So it's not a bad thing to have. So using that as a frame, hindsight bias is just the fact that when we see something, and it's why it's closely related to outcome bias, is that when we look backwards, hindsight, is that we're able to discern stuff that supposedly we would have known prior. And the easiest example I can give of that to the group listening would be, think about how many times after something occurs and you say, well, it was obvious, we shouldn't have done that. Well, if it was so obvious and the people you're talking to are your friends, they're not idiots, then why did they choose that?
Or your friends might
Well, they
be
chose
idiots.
it simply because at that time it wasn't obvious. Hindsight bias is that idea by looking backwards, we can point out the one thing, the obvious thing that we should have known differently. And we have to be very careful about that when we're determining what was reasonable, because a person in the middle of making the decision does not have the luxury of hindsight. They don't know what the future is going to be. They don't know if they would have done this, it may have turned out differently, or that kind of stuff. What they're dealing with is in the moment. So hindsight bias is a very critical thing that I warn and caution analysts and review to be aware of themselves that they may be putting it in. The other one that you mentioned was outcome bias. And outcome bias is a choice, both either conscious or subconscious, below the level of awareness, that we determine the value of something based on the way it turned out. So the old adage from a systems methodology is that a system process can create desirable outcomes and undesirable outcomes. Sometimes a really good process, one that's really efficient, can still end up with a bad outcome or an undesirable outcome. Sometimes a bad process can end up with a good outcome or a desirable outcome. If you concentrate on the outcome and then go backwards, you're also contributing to hindsight bias. So if we look at the way something turned out, and I'm going to apply this directly to use of force. In lethal events and use of force where life has been taken, expired, the one given is that it's always a tragedy. The outcome.
Objection, Your Honor. Killed a pedo. I wouldn't say it's always a tragedy, Your Honor. No, he's doing this. This is actually really good discussion, because the Binger, the prosecutor, right? One of the things he said earlier in the hearing was, this is why we don't want 17-year-olds running around with guns, because 2 people died. It's like, oh, fuck you. Bunch of people run around with guns and no one ends up dead. These people made decisions that ended up getting them killed because they tried to kill Kyle Rittenhouse. Like, frankly, that's what happened. They were attempting to cause severe bodily harm to Kyle Rittenhouse, and they paid the woke toll for it. So that just because people died doesn't mean the wrong decisions were made. But it's easy to say, oh well, no, wish no one would have died. You'll hear me say that a lot, right? Like, especially in police use of force encounters, even when I think the cops are justified, a lot of times I don't want them to have shot someone and kill them. One, even if the person that they shot and killed is an absolute scumbag, you don't want the cop to have to live with that decision. I mean, killing someone it takes its toll psychologically on people. And so you don't want the cop to have to go home and live with that. You want all encounters to be resolved peacefully if possible. And so when someone dies, the justification of it, doesn't change the fact that it kind of sucks that someone dies. Most of the time, I will shed no tear for Joseph Rosenbaum, or for Huber, or for the bicep of Gage Grosskreutz, or whatever. You won't catch me ever being sad any of them died. But there are cases where it happens, and it sucks that someone died. But that doesn't mean that the shooting wasn't justified just because you feel bad that someone ended up dead from it. In fact, there's real tragedies are where people make self-defense shootings that are completely justified, but based on mistake. And the mistakes are reasonable and they provide for the justification, but the person still dies, even though there was no criminal intent. Those are the real tragedies, and those shootings can still be justified, even if the person wasn't actually a threat to them. If they were perceived as a threat, and it was reasonable to make that perception based on the circumstances, then it happens, and it sucks. It really does. But it doesn't mean that the person has to go to jail forever.
Is not something that we wanted, so to speak, society in general. But that doesn't necessarily mean that what led up to it or what didn't lead up to anything else. And if we look at only the outcome and we go backwards, that's also problematic, much the same way hindsight is. So an outcome bias, it's a concentration on the outcome as determining the value of the system as a whole.
When you reviewed this case, did you form an opinion as to whether or not Kyle handled his firearm in a proper manner during incident 1?
Not so much during incident 1. The video didn't really show enough clarity of handling characteristics. There was a lead up to that where he had his weapon slung, and everybody has different tactics about what is proper or not. If we just consider handling in a safe manner, his weapon was pointed down most of the time and these type of things. He didn't seem to be reckless with his weapon in any way for the stuff leading up to event 1. And event 1, just for clarification of the court, we're referring to basically the gas station, correct?
We've kind of referred to it as Car Source 3. It's we would agree at 63rd and Sheridan. So we're all on the same page.
Yes, sir.
And now going in.
Did he handle it right? Of course he did. He pulled the trigger 4 times, and those 4 bullets went into the pedophile that was trying to harm him. He didn't shoot anybody else. He didn't recklessly discharge into his own foot. He didn't shoot up into the air like a moron, like Boogie. He didn't do any of that. He put bullets on target without harming anybody else. All of his firing, went either. Did he miss ever? He may have missed one shot somewhere, but I'm trying to think. I don't know if he did.
To event 1, were there any environmental factors that came into play at that time?
Oh, I would argue yes. I mean, if you think about it, one, you have the actual act of, just think about the nature of the dynamic, and I'll use environment in broad context, not just temperature and light and that kind of stuff. The first one is he's obviously, not obviously, but it would appear that he is moving away from somebody to be pursued.
It's obvious.
There's an object being thrown at him, which means he is the defender, or he is in a reactionary mode. He's trying to gain distance. We have low light situations. We have a crowd. We have a large amount of noise. We have a bunch of people filming. We have differentiations in light. You have it lit up more where they're going to and not as lit on the street. So all those things affect things like vision, your hearing, your ability to process a stimulus. So the short answer is yes.
And you used the term he was reacting. Could you describe that more?
Yeah. The idea of reaction is the most simple way to do it is something else is being observed, is pushing, is doing something, it's acting as a stimulus, and then you're not the initiator of your action. You're playing catch up to their side of the equation, so to speak. This is commonly referred to in different things as, an OODA loop: observe, orient, decide, act. And it's also referred in infrastructure in the same type of decision methodology: sense, anticipate, act, learn. I mean, it really doesn't matter. But the idea is something else outside of you is the initiator of the action, which means that the action you're doing is a reaction. You're reacting to their stimulus, that variable, or something similar.
And the acting force in event number 1, would that be Mr. Rosenbaum?
Again, I can't speak for the mind of Kyle Rittenhouse, but I would think it would be absolutely expected or reasonable that that would be the causal action, because up until that point, he was not moving in that area. So.
And in your evaluation of the
Max Hines says the media has done their best to clean up the images of Anthony Huber, Gage Grosskreutz, and Joseph Rosenbaum. Oh yeah, and they're trying desperately to taint Kyle Rittenhouse's image. That's what they want to do. There are still people who believe that he brought the gun across state lines. As if that would necessarily matter, but there are people who believe that. There are people who believe that Kyle Rittenhouse had no business in Kenosha, Wisconsin, that he has no connections there, that he should never have been there because he's from Illinois, and that he's so far away and all this stuff. They have no idea, because the media has just told a lie about it. I mean, that's the answer. They've just told a lie about what happened because they want to protect Black Lives Matter and Antifa.
things that happened in event number 1 at Car Source 3, what factor, if any, does the concept of novel situation play a part?
Yeah, again, that's so when people are exposed to something that they've seen before, a driving event, you've been to the range and you've gotten your concealed carry license as a citizen, whatever it may be, the more that you get exposed to something, it is not as novel, and you begin to build basically ways that you react to it. And we're just going to call those heuristics. They're sort of like subroutines. You don't think about them a lot. You don't think about how you hold the fork or how you drink a cup of coffee anymore. You just reach for the coffee and the drink. You don't do it until all of a sudden, when you drink that cup of coffee, you put salt in it instead of sugar by accident. And all of a sudden you realize what you're drinking isn't what you're supposed to be drinking. And now all of a sudden you realize your subroutine isn't working. It becomes, for lack of a better term, novel. The first time you've been exposed to it or something highly unexpected. When you're in that area, you don't have a library of choices to pick from because your library hasn't been filled up with the metaphor of those books. So you're creating your choices and your actions on the fly. You may have expected something, but all of a sudden it goes that. And many people have been in those situations. Avoidance of a car accident. All of a sudden you're swimming in water and it's way too cold and you realize you're being pulled out. It's a tough place to make decisions at because it can be overwhelming. In
this novel situation, assuming this is the first time Kyle Rittenhouse had ever been chased by somebody in this situation, is one of the choices flight? Oh, absolutely. Yeah, you can. And did you see evidence of flight on the part of Mr. Rittenhouse? Again, flight would be a subjective term. I see evidence of Kyle Rittenhouse moving away from what would be perceived as his adversary. And do you see his I'll use your terminology, adversary do any physical actions towards him?
There is indication in the video that there's a closing of distance, and the closing of distance is occurring in a narrowing of space of movement, the space between cars and this kind of stuff. So the thing is, we have this idea of getting close, and I don't have a lot of room to maneuver. And then also the idea that if we're that close and we're being pursued, we're now bringing a weapon, a lethal weapon, into this.
Remember, guys, that he can't speak to Kyle's state of mind. If he starts speaking to Kyle's state of mind, that's not his job. He's an expert witness in decision making and the reasonableness of decisions, but he can't say the motivations behind those decisions because he's not Kyle Rittenhouse. And if he starts making that testimony, then the prosecution will rightfully object and can actually disqualify him. So he has to be very careful not to say Kyle was retreating, because he doesn't know that Kyle was retreating. It looks like he's retreating. He's moving away from who could be perceived as an adversary. Is about as close as he can get to say it. So you got to understand, this guy does this. Like, this is his job. You know how there's useless PhDs, right? And they just go be professors. Well, the useless PhDs who don't become professors should become expert witnesses if they have the right types of expertise, because it pays really, really well. And so, you know, this is why this guy is a use of force expert who is subsequently been invited to offer testimony in 63 different trials. It's because of this type of very careful testimony that is hard for the opposing party to impeach and to say, oh no, he's just shilling on behalf of Kyle. This isn't expert testimony. This is just character testimony or whatever. This is bullshit. They can't do that as long as he stays very focused in talking about the objective facts. Objectively, Kyle is moving away from Joseph Rosenbaum. Is he fleeing and retreating? Probably, but he can't say that. So calm your tits a little bit about the way he's wording things. He has to word it this way.
And that is Kyle's weapon, because if he doesn't retain that, that can be a lethal weapon on either side. And so those actions are all, I think, reasonably portrayed within the video and the evidence.
And when you say he wanted to retain that, what do you mean?
Yeah, and I can't speak for Kyle Rittenhouse. I don't know whether he wanted to retain it or not, but I would argue that that a person that has a weapon, such as a firearm, that one of the things that you want to do is to maintain control over it for two reasons. One, so that you're not unsafe to others. You don't inadvertently pull the trigger when you shunt or trip or do something with it. And the other thing is that you don't give a weapon, so to speak. You have your weapon taken away, and then it is now used on yourself or others. One of the common things you see, just a sling carrier with holsters for pistols, is they are a form of retention, some better than others, some not so much. But when they use the word retention speaks to, does that person maintain control of their weapon?
And to your training, understanding, would it be reasonable for a person to want to retain their firearm from another person who has threatened to kill them in the past?
Yes.
Why?
Because if their firearm is taken away from them, and if they believe that person to be willing to do them serious bodily harm or anything else, a reasonable perception would be, once they take that firearm, they're going to potentially use it against me.
And
Shocking.
in your report, you talk about motive and action. One of the key words that you use is the word means, correct?
Yeah, so I don't necessarily talk about motive, but I think what you're referring to is intent, means, and opportunity as a way of helping to give a framework for understanding use of force decisions.
Okay. And would you comment on means as it applies to the event number one? What would be the means?
Well, yeah. So the short answer of that intent means opportunity in a really quick synopsis is means is the tool, whether it could be a fist, a knife, a gun, or whatever. Opportunity is the ability to use that tool. For example, if you had a knife, but you were 100 feet away behind a closed door, you'd have a means, but you won't have opportunity. And an intent is a demonstration of the willingness or their intent to actually apply the means with the opportunity. If any one of those are missing, then it sort of doesn't work. So in this case, the means would be the fact that there was a weapon on scene, Mr. Rittenhouse's, but also the means exist on the adversarial side in that the means are fists, a willingness to engage in physical confrontation, any of these type of things that if Mr. Rittenhouse perceived that, that would be means that would have nothing to do with him. And again, we haven't had any comment on that yet.
And opportunity, how does it apply in event number one?
Well, it's a critical
Closeness.
No,
Go ahead.
and you just hit on it. The fact is, I have in the first couple of moments, the frames, we see the pursuit across the parking lot, and at that point we have I'm not going to estimate the distance. I haven't done any mineralogical studies on it. I don't think it's that critical at the moment. But what we see is a closing of the distance. And so the closer and closer we get, where we get into the space of physical confrontation, the criticality comes down to now the lethal firearm, Kyle Rittenhouse's firearm, is now a potential weapon for both parties, not just something Mr. Rittenhouse would use either lawfully or unlawfully. But the idea is, in this case, when we get closer and we get into this potential range of the wrestling match, so to speak, where I'm one hand's distance away or 1.5 steps, so to speak, now that lethal weapon is part of both sides of the equation.
And after the fourth shot is fired in the area of Mr. Rosenbaum, you see on the video, because I'm trying to move this along, Mr. Rittenhouse continue, run around the car and come back to the site where another individual is giving Mr. Rosenbaum aid?
Yes.
And you see Mr. Rittenhouse make a phone call and then begin to run down the direction of Sheridan Road or to Sheridan Road and then in a northerly direction. Is that a first statement?
Yes. And again, the concept of run is subjective, but he was, whatever term we want to give, jogging, moving faster than a walk, but yes.
Don't call him a jogger.
And that's kind of the events, the running down Sheridan Road is what leads us to event number 2. Is that a fair statement?
Well, yeah, but it's two sides of the equation. The running, it places him in Sheridan Road, but it's the fact that there's a crowd and he's in this crowd and that you have two sides of the equation, the crowd and him. So the running puts him in a location, but running itself didn't cause the event, I would say, other than maybe the fact that he was paused in his running when he stumbled.
Okay. And you see a crowd.
He was hit.
Gathering or coming towards, surrounding Mr. Rittenhouse. Is that a first statement in the videos?
I think that's fair.
And there's some physical contact made by Mr. Rosen, by individuals, and Mr. Rittenhouse goes down on the ground, correct?
Yes, that's correct.
And between event number 1 and him being knocked or tripped to the ground, do you see him handling his firearm?
Yes, and just a clarification of the past one, I'm not going to, we see a stumble and a fall. I don't want to imply necessarily that he was knocked to the ground. but at the point of the handling, he had maintained his weapon, and he's on the ground with his weapon, which is a long gun, or often referred to as a rifle or firearm.
He was struck and
as
then
he's
fell to
going
the
down
ground.
Sheridan Road, is he recklessly pointing his firearm at people he thinks may or may not be a threat? Is there any evidence of that?
Not that I've seen on any of the video that's been given to me. In fact, I think he only looks over his shoulder, if I remember correctly, maybe one time. His focus seems to be on moving forward in his direction of travel.
Okay, and when he does that, that's the individual who runs up to him and films him and says, "Hey, did you just shoot somebody?"
Yes, and it's in that direction. Even when he got back up after the event, he still went off in the same direction that he was initially depicted in moving towards.
Okay. Now, when he's on the ground, does Mr. Rittenhouse immediately open fire on anybody or who's around him?
Not depicted by the video evidence I saw.
Okay. Does he point his firearm at individuals who might be near to him without firing?
I say it's pointed in the direction. I mean, he's surrounded by 360. If his firearm is up greater than 10 inches off the surface of the pavement, it would be pointing the direction of somebody. So yeah, the short answer is he does point it in the direction of. I mean, it's a firearm. The bullet travels long distances depending on the ammo, and so the thing is, he does that without firing initially.
Okay. And you can see some people react to the firearm without him firing and backing off, correct?
That's correct.
And describe what starts the shooting in event number 2, to your professional opinion.
Well, you've got a couple things going on, but I think the easiest way to describe it is if you were to think of a small circle drawn around Kyle Rittenhouse of some distance, whatever it may be, you've got layers of the crowd out there, and then what happens is someone is inside of that circle and moving towards him, and basically it makes contact with him physically and knocks him off balance. Now, what he was trying to do is up to him to tell the court or not. But the idea is, it seems like he was sitting up. He was getting stable position. We know later on that he got up and tried to move again towards where the police were. So the first thing is,
one law student says, "Your Honor, my opinion is Kyle is a member of FaZe Clan. Dating by the shot, I'd say FaZe circa 2010. Okay. The no-scope jokes are good.
Is someone coming in from the outside, using physical force to knock him off balance. And I would say that's where it first starts.
And when someone approaches him and they place their foot on Kyle's face, some would say that's kicking him in the face, correct?
Yeah. And remember, in that event too, if you look,
Placing a foot on someone's face is how my kids would describe kicking their sibling in the face. Yes. I didn't kick him in the face. I set my foot on their cheek. What are you talking about? Kicking him in the face. That's just mean. By the way, in case people don't know, Bob is the expert for the prosecution. I don't know if he's going to get to talk today or not. I think someone said no.
look at the dynamics of that person had momentum as well. It wasn't just, I stood there and I pushed someone with a foot. One can, just by the very nature of, in this case, the adversaries, and we'll call this person adversary number 2, his 1 foot, it's a jump. Both feet are up in the air, which would indicate that there is some sort of momentum being involved in this as well. So.
And that individual is wearing what would commonly be referred to as heavy work boots?
I think that's fair.
And that in and of itself could cause a fatality, correct?
It's possible. I mean, a kick to the head,
yes.
if applied with enough force, can cause damage that could be potentially fatal. I'm not a medical expert. I can speak to it.
Yeah, okay. Yes, a 200-pound guy leaping into the air with work boots and landing on your face can kill you. Yeah, I'm not a medical expert either, but I'm pretty fucking sure that can kill you. And if you let's just ask the prosecutor. Hey, prosecutor, guess what? Let's say hypothetically, you have to charge someone who leapt into the air and landed on someone else's face with work boots. Would you prosecute that as an assault with an intent to cause severe bodily injury or death? Would you prosecute it that way, or would it be like a misdemeanor? What would you do, Mr. Prosecutor? And the fucking liar would say, well, I don't know, because he's a goddamn liar, because prosecutors are goddamn liars. And the fact that they didn't prosecute Gage Grosskreutz, and they didn't track down and prosecute the guy who jump kicked Kyle Rittenhouse is a fucking sham.
From martial arts knowledge and reviewing homicides, the fact is physical force applied to the head area can be fatal, or at a minimum.
Yes, any physical force applied to the head area is treated, by the way, as deadly force. In basically every application where they're going to talk about physical force being applied to the head, especially when it's used as justification, that is deadly force being used. And anyone who is being hit in the head is in reasonable fear of deadly force. If you want evidence of how that works out, just look at how it worked out for Zimmerman, right? Trayvon Martin is taking Zimmerman's head and rocking him against the pavement. Was it going to kill Zimmerman? It didn't. Might it have? Yeah, maybe it would have. If it had gone on longer, but it doesn't have to have gone on longer. One crack pops a crack on the skull, causes a brain bleed. You end up dying, days later or right there. Who knows? That's how any sane, rational look at any of this stuff shows that Kyle Rittenhouse was being attacked with deadly force, at least from the time that guy jump kicked him. And was certainly being attacked and was justified in using deadly force against Rosenbaum. It's all silly. Everybody in this courtroom, including this gay fucking prosecutor, knows that this shouldn't even be on trial. They all know it. Bob knows it. Look at him. Bob knows he's a cuck for the fucking government. They all know that none of this should be in trial. Bad Vibe says, your no ship, I object. I call hacks. Kyle used auto-targeting. Yes.
Cause loss of vision, blindness, hearing, breaking of the orbital. I mean, I'm not going to speak to the medical part. I'll just speak from my knowledge personally that I know that being kicked to the head can cause severe damage, serious physical injury, and is a potential to cause death, yes.
And in event number two, adversary, you refer to him as two, but I refer to him as jump kick man. That's the first person that Kyle shoots at after Mr. Rosenbaum, correct?
Yes.
And after jump kick man makes contact with Kyle, what happens to Kyle, according to your review?
Well, there's a bunch of things, but the short answer is he gets attacked again.
Okay. And attacked by hands or attacked by an object?
Object. Basically, another person now is entered in the fray. And I've served on mobile response teams, and I've done other stuff, and I've been in other nations, Bosnia and everything else, and I've watched crowd dynamics at play. It's not uncommon that, you know, once something starts, it begins to escalate. And so now you were
I
saying
didn't mean to
something?
cut you off. Go ahead.
Okay.
I didn't
So
mean to
now
cut you
what
off.
you see is this progression. So the progression isn't necessarily unexpected. One person's tried it, and now we have another person coming in with a skateboard, and they use a skateboard as a weapon against Mr. Rittenhouse.
And to your viewing, striking him where?
Head neck area. I wasn't able to determine if it was, you know, like above the neck and only to the head or down there, but I'd say the head or neck area is a good general assumption for the video.
And after this individual strikes Mr. Rittenhouse with his skateboard, he does what?
He continues to stay engaged with them. So this wasn't just a run by and, you know, this isn't like running through the sprinklers and getting wet and then coming back out. This person is, after he does the first, we'll call it a strike with the skateboard, you know, hard wooden, you know, I mean, think about getting swung out with a bat. But the fact is, he's taking his body weight with both knees and staying on Mr. Rittenhouse. Now, I think that's interesting because this would be indicative of him or an assailant as a way of establishing control. Whether you're a student of ground fighting, whether you've been trained in a civilian police academy, whether you've been trained in anything.
Rumor has it he said, "Hey, Kyle, it's time for ground and pound." And by pound, I mean your anus.
The idea of putting knees down on somebody to use it as a way to potentially pin them or control them are techniques that are commonly taught.
And as he places his knees on Mr. Rittenhouse's chest, does he do anything with the hand that doesn't contain the skateboard?
Yeah, he reaches for the gun.
Yeah, and this is the ongoing part. So we have a strike. We have a attempt to control. And so the question is, what's the goal of this? Well, you can see that in the video that the left hand of the assailant is now beginning to go the body line. It's beginning to drop below the body line. And so the question is, what's down there and why would his hand do that? And my argument would be is if that hand is down there, that hand
He's either reaching for a gun or reaching for a penis. One of the two. What's down there?
is potentially going for the weapon, going for the firearm. Now, can I say that with absolute certainty? Of course not. I can't speak of the mind of the assailant. Can I say with reasonable certainty, and that it would be reasonable if Kyle Rittenhouse had perceived that? Would I say that that's a reasonable perception? Yes.
And when this individual goes for the firearm, is there a reaction on the part of Mr. Rittenhouse?
Well, eventually, well, there's a struggle. I mean, the fact is, you can see in the multiple frames, this Mr. Rittenhouse is holding on to his weapon to maintain control of that weapon. It's being pulled because you can see this the motion of assailant number 2 going away. He's not going into Mr. Rittenhouse. He's going away, and when he's going away, he's got his hand specifically on the weapon itself, and so he's pulling the weapon. And when he's pulling the weapon, at some point, obviously, approximately 0.684, the response is that Kyle Rittenhouse fires.
So, in your review, just so it's clear, in your review of the video, you can see initially the hand going down below the body, and at that point, you're not willing to say he's grabbing the gun, but in later frames, you see the assailant exercising force on the firearm, trying to remove it from Mr. Rittenhouse's person. Is that a fair statement?
No, it's absolutely fair. And so the thing is, on the first question,
No,
I
that's
can't know.
absolutely
On the
fair.
second question, how did his hand get to the gun, which we do know, it's in the evidence, it's sitting right there in front of us. It had to occur between the time of the struggle and the time of when the second assailant has gone back to standing. So again, with reasonable certainty, like I said, could we assume, even though his hand was out of view, that he was getting control of the weapon? Well, yeah, because how else would his hand be on the weapon in the next frame?
And this all happens very fast.
Oh yeah, I mean, amazingly fast.
And how many times, with your review, does Kyle Rittenhouse...
Welcome to John Black's sexy evidentiary hearing hour, where John Black will woo you with his sultry voice, telling you about grabbing guns and pistons, rifles.
shoot assailant number 3?
If I'm making sure that I'm counting your assailants correctly, that would be 2.
The gentleman with the skateboard.
2 times.
How many times?
You're saying shot?
How many times does Kyle Rittenhouse shoot from your review, the individual with the skateboard, not jump kick man?
No, with the skateboard 1 time.
Okay. And that individual goes off to one side to move this along. Is that a fair statement?
Yes.
And in your review of the video, does there come a time where he's approached by, in event number 2, a third individual, assailant
Yes.
number 3? Describe that.
Yeah, that's an interesting one. This is, at least as depicted by video evidence, and other interviews as well, the only person that's actually going up now that has a firearm. This person has a pistol, and that makes a difference. And then the other thing that's sort of happening about that is there's really a difference in the movement pattern of this one, because at this point, after Mr. Rittenhouse had disengaged from, if I'm making sure with your count, we'll call him Skateboard Man, just to make sure we're not using numbers. If he had disengaged from Skateboard Man, we now have a third person in event 2 approaching and coming up on him. And that's, for lack of a better term, interesting. Go ahead.
And that individual has a firearm in his hand, correct?
Yes.
Describe the interaction between Mr. Rittenhouse and assailant number 3.
Yeah, there's a lot of stuff going on in here, and one in particular is we've got the approach. So the first thing is assailant number 3 closes distance. Now, we talked earlier about context.
Really stupid of Gage, by the way. Must not be a good marksman. Probably worse now. But you'd think he would have just stayed back, drawn his weapon, and fired at Kyle, right? Like, that seems like the reasonable course of action. Instead, he puts himself directly into Kyle's line of, not just line of fire, but directly into his attention. Like, he comes up on him. And I know he does this little thing. He's trying to be sneaky. But instead, he should have stayed, 10 yards away, pulled his gun, and just blam, blam, blam. Like, if that was... Fucking dummy. Good thing for Kyle that this guy's so idiotic. This is really a stupid plan.
He closes distance with someone that has been wrestling over a firearm, and up to this point had discharged his weapon multiple times, that we would argue that assailant number 3 would have been aware of this. They've seen the idea. Now, at the same time, he hasn't sprayed the crowd. He hasn't done anything.
When you refer to he, I'm sorry to interrupt, but when you refer to he, who hasn't sprayed the crowd?
And absolutely correct. That's my fault. Kyle Rittenhouse has not taken his firearm and basically just pulled the trigger without any regard to anything and just sprayed the crowd as a vernacular to get back. But he has had very directed fire, deliberate choice in very specific context. The specific context would appear to be, I need to maintain control of my weapon. When the fighting of the weapon starts at, because even the attack itself is still the struggle over the weapon, ultimately. But what's funny, and I don't mean this in a demeaning way, what's odd, I guess, is a better term,
yes, you do.
is that the third assailant has his hands up, we'll call it a universal symbol of either surrender or peace, or the fact that I'm not an aggressor. I mean, in fact, we still shake hands today to show we don't have a weapon in it. We still do these type of things. Even the military salute to some degree is based off of that history. And yet when I'm doing this, I still at some point, I being the third assailant, I change my movement pattern. And you can actually see it in the video where I load, which means I sort of, if anybody's ever sprinted or about to push something, like even push a door open when you came into the courtroom, you sort of brace off your back foot while you're loading up so you get better contact and better connection with the ground to apply your musculature through the door. You can actually see assailant number 3 load and go forward and re-engage. And you see that also not only by the loading of the foot, but the dropping of the torso and the shoulders. And so the thing is, this would be in direct contradiction to an expected behavior of someone doing something else other than moving in. And then ultimately with that one big, large step, when you see them stepping in, and don't forget the context, there's still people running around with wooden objects, potential things to hit people with and these type of things. And basically the third assailant ends up getting shot one time as that type of dynamic is occurring.
As he gets shot from the first position with his hands up to when he's shot in the arm, is he moving away from Kyle Rittenhouse or moving towards Kyle Rittenhouse?
I would argue that the evidence shows that he is moving towards. But again,
and that's where he struck once in the arm?
In the bicep, if I recollect correctly, yes.
And that's the last shot that Mr. Rittenhouse fires on August 25th of 2020?
Yes.
And Mr. Rittenhouse then gets up from his seated position?
Yes, at least as depicted in video.
And he begins heading down towards the police line on Sheridan Road?
Correct. He continues to head in the same direction that the beginning of the event started.
And in the videographic evidence, there's 3 more shots in quick succession?
Yes, and yeah, you can hear it on the soundtrack, but yes.
And does Kyle shoot at those shots, or the direction those shots are coming from?
Does Kyle
Kyle doesn't shoot.
Can you rephrase that question, please?
Does Kyle take his firearm and fire in the direction that he perceives those shots coming from?
I don't know where Kyle perceived the shots to be coming from, but I don't see any indication that Kyle fired any shots based on that stimulus.
He does turn around shortly after the shots, correct?
Oh yeah, he turns around from the sound, but again, I don't see any indication that after he turned towards the sound, he also fired his weapon.
And then he runs towards the police line in the video with his hands up, correct?
Correct.
And you've reviewed this for whether or not Kyle's actions were reasonable under the self-defense law of Wisconsin?
That's correct, under the Wisconsin statute.
And do you have an opinion as to that to a reasonable degree of scientific certainty?
I believe the actions comport with it and that self-defense as described in the standard, not speaking as a legal opinion, but I do believe that they were reasonably necessary.
I was doing event one first, Your Honor. Doctor, you understood that I was speaking of event one?
I didn't, but using the same, using that as the question, I would say that the event one actions were objectively reasonable, and they comport with the idea of reasonable necessity under the Wisconsin statute, as I understand it.
And you've testified to the factors that go into that determination, correct?
Yes, sir.
And as to the shots fired in event number two, is it your opinion to a reasonable degree of scientific certainty that those shots were also reasonable in the endeavor to try and protect Kyle Rittenhouse's person?
Yes, and speaking specifically, I would argue against the three assailants as the condition to that understanding, but yes.
And you refer to the three assailants. Does the fact that there are multiple assailants enter into your factors?
Oh, absolutely. And when I say three assailants, I just meant the assailants that made the choice to interact with Kyle Rittenhouse that evening.
And there were actually more than three potential assailants at event number two. Is that a fair statement?
There were many people milling around. Their actions would indicate agitation, potential aggression. They were carrying things that could be used as weapons. They were obviously not pleased with what had occurred and were in a high state of emotion. I mean, that's depicted by just some of the soundtracks of that. So we have the actual assailants, those that chose to make contact to physically assault Mr. Rittenhouse. And then you have the potential, and that's what I was trying to describe when I described the different circles of those different layers. And those, it's very common in crowd dynamics. It's not an uncommon event.
When you say crowd dynamics, one of the labels of a crowd dynamic is mob mentality, correct?
It can be. It's not always there. I mean, we have peaceful protests every day. A lot of it is the what they're choosing to do, and but yeah, I mean, we talk about crowd dynamics. It's just the dynamics of the crowd. If we have mob mentality, can we have people pile on to something, or the anonymity, or their willingness to do stuff that they wouldn't normally be willing to do? That's more often attributed with, we'll call it the concept of mob mentality.
Thank you, Doctor. I have no further questions.
Yes, sir.
Let's break at this point, and I'm going to ask that you return at 1:20.
Your Honor, I have a court this afternoon. I have a conflict.
Thought this would all finish in 2 hours' time?
I'm sorry?
You thought this would finish in 2 hours' time?
Where
do you have to go?
I thought we'd scheduled this for 2 hours, Your Honor.
I think you're right about that, but where do you have to go?
I have initial appearances this afternoon starting at 1 o'clock before Commissioner Keating.
No one else can handle those?
I can see if someone else in the office can.
Yes, someone can handle the initial appearances cattle call. You fucking guy. Everything this prosecutor does makes me want to uppercut him right in his vagina.
Are you available this afternoon?
I'll make myself available, Your Honor.
Unless there's a specific case you want to cover over there.
No, I can see if someone else in the office can, Your Honor.
Okay, let's try to start at 1:20. I have a 1:15.
Can we make sure the witness is available? Dr. Black?
Yeah, good question. Doctor, are you available at, what is that? What is it? It was just after 10 there, is that it?
Yeah, it would be 11:15 my time, Your Honor.
Are you available then?
And I will make myself available.
And Mr. Willis, will you be available? Where
Yes.
are you physically?
I'm in the state of West Virginia.
Oh my God. Did we hear that? It sounds like me. I'm in the state of West Virginia. Oh, Jesus. If we have to listen to that guy, I'm gonna die. Oh, he just made me worse. Oh.
Okay, so you're at one little after 1 now. Are you available at 2:15?
Yes, I am.
Okay, great. Okay, 20 minutes after then.
How long does the court anticipate going this afternoon?
Till we're done.
As long as it takes.
Okay.
Yeah!
Thank you. Thank you.
Thank you.
Till we're done. As long as it takes. As long as it takes. Good answer. Queen Nidus says, Kyle's an absolute Chad. I would have gone full Christchurch on the crowd. At the point of the first contact by Jump Kick Man on Kyle's, the place became a target-rich environment. That would be how a lot of people would have handled this, right? And again, that it just goes to show.
Hi, I'm Dan Abrams.
Oh,
And the
Jesus
exploding
Christ. Why Kyle was so remarkable in all of this. Okay, let's see. Let me get to part 2. Wait, what? Where the fuck is the... Where's the other one? Did they unlist these? Oh, Jesus. Hold on. There it is.
Are you resting?
Don't know why this is so hard to find. I wonder if they unlisted it. Okay, we're gonna get rolling on this. It should be the prosecution's turn. Bob has moved. Bob realized that he looked like an absolute degenerate in whatever. What an embarrassing appearance by Bob here. Notice this guy's got a suit. He's clearly in a study of some sort. He looks weird. He gets some weird sort of lighting, but he is well lit. Bob looks better here, but it looked like he was in a cabin somewhere. Even this setup is just, it's like not good. He doesn't look professional at all. He's in a short sleeve shirt. I mean, you're about to testify. You're about to testify in one of the most watched important trials ever, and you're testifying on behalf of the state, and you're in a fucking, you're in a short sleeve shirt. What are you doing? All right, here we go. We're gonna get right into it.
So,
Rested, just so the record's clear, 1 and 2 we agree are admitted.
received.
Thank you.
Mr. Finger.
Thank you. Good afternoon, Dr. Black. I wanted to ask you a couple questions regarding your curriculum vitae. Do you have that in front of you?
I do.
That is Exhibit 2. And on page 4 of your curriculum vitae, at the top of the page, there is a heading Expert Witness. Do you see that?
I do.
And you wrote there, and I just want to make sure I'm quoting this correctly, you said, qualified as an expert witness in state and federal courts related to police use of force, decision-making, officer-involved shootings, police tactics, police training, incident command, and police/jail operations. Did I read that correctly?
You did.
Is it fair to say then that the times that you have been qualified as an expert witness relate to police use of force as opposed to civilian use of force?
I'd say the majority would be related to police use of force. That's correct.
In your CV, you have a section where you list the cases that you have been involved in as an expert witness or a consultant. Those begin on page 24 of your CV. There are 57 cases that you list running from there until page 32. Is that correct?
That's correct.
Is it correct to say that in every single one of those cases, one of the parties is a law enforcement agency?
No, I don't think that's correct. At least on some of the advisement, I've advised on civilian self-defense before. I'd have to take a look at which one and when I'm. So the short answer to your question, sir, is no. I'd have to go through them, but I have advised on self-defense cases before.
All right, well, let's go through them quickly here. Number one is a case involving a defendant, Washington County, Oregon, correct?
Yes,
That's your home county where you worked as a sheriff's officer for many years?
that's also correct. It's not my home county
And-
now. It's a home county where I used to work.
And that's a case involving a law enforcement agency since the county is a defendant, correct?
Yes, absolutely correct.
Number two, similarly, Clackamas County, Oregon, same situation, correct?
Same situation, meaning that a law enforcement agency was involved?
Yes.
Yes. Mm-hmm.
Number three, a police shooting in the Northern Territory, correct?
Correct.
Number four, Chicago Police Department shooting, correct?
Also correct.
Number
We're gonna go through
five, another
57 of
Chicago
these.
Police Department shooting, correct?
Correct.
Number six, a case involving Jackson County, Oregon, a law enforcement agency there, correct?
Correct.
Number seven, a case involving Seattle law enforcement agency, correct?
Correct.
Number eight, a case involving San Jose law enforcement agency, correct?
Correct.
Number nine, a City of Aberdeen, Washington law enforcement agency, correct?
Correct.
Number 10, a St. Helens, is that St. Helens, Oregon?
That is correct.
Law enforcement agency there, correct?
Yes.
Number 11, a Washington County, again, Oregon law enforcement agency, correct?
Correct.
Number 12, King County, which is Seattle, Washington, law enforcement agency, correct?
Yes, sir. It's correct. And
Number 13,
go ahead, sir.
Number 13, Yamhill, Yamhill County. I don't know where that's at. Maybe you do. Well, I'm sure you do. But anyway, that's in.
The prosecutor here thinks he's making a very clever point. Well, you've only talked about police stuff. He's doing a performative questioning, but he's in front of the judge. He's not in front of a jury. This isn't really useful at this stage. Like, the judge doesn't care, right? Like, the judge is not like, oh man, prosecutor's really getting him right now.
Involving another law enforcement agency, correct?
Yes, correct.
Number 14, Springfield. I'm not sure which Springfield that's at, but that involves a law enforcement agency also, correct?
Correct.
Number 15, Portland State University. Is that involving a law enforcement agency?
It's a type of agency. It'd be campus security.
Number 16, another Washington County case, law enforcement agency, correct?
Correct.
Number 17, Eagle Point Police Department, another law enforcement agency, correct?
40 to go.
Correct.
Number 18, Yakima County, another law enforcement agency, correct?
Correct. And sir,
Number 19, go ahead, I'm sorry.
No, and again, if you'd like to read through each of these ones, but as a courtesy to the court, I think maybe there's a misunderstanding in the statement. What I said is I have advised in self-defense issues. Not all of that. If you notice when I testified in this morning's thing, I said 60 instead of 57. I routinely get calls. I issue things in self-defense. If you're asking if I've testified in a self-defense case, that would be different than advising. But if you'd like to go through the remainder of this, we can.
Is it fair to say, though, Dr. Black, that the 57 that you've listed in your CV all involve law enforcement agencies?
I think that's fair to say.
Okay, thank you.
Oh, Jesus.
I
Thank
think that
goodness.
statement is, I understand it's cross-examination, but sometimes he's a plaintiff representing the plaintiff who was possibly shot. And was there a law enforcement agency? It's a misleading question.
Well, then the witness he's an expert witness, so I think he can handle it. If he doesn't, you can cover it on redirect.
Sounds good.
Dr. Black, you also have a long list of trainings and instructions that you've done, and I have looked through this list. Can you help me focus on the ones in which you have trained on civilian use of force as opposed to law enforcement?
Well, what do you mean by civilian use of force? Just anybody that doesn't have powers of arrest?
Let's go with that definition, sure.
Okay. So, and would that include, we'll call it military militia or self-defense forces from a military perspective?
I would lump them in with law enforcement, not civilian.
Even if they were not military forces per se, but civilian, we'll call them augmentees.
Why don't you point me to the ones that you're referring to on that particular point?
Well, I can't. I'm trying to answer the question the best I can. I routinely trained those type of personnel, and I didn't list every mission I've been on in 30 years of the military. Again, I'm just making sure that we have clarity of the question. So I'll start with the first one. What page are you starting on when you say I'm looking at your training?
Well, I'm focusing on pages 33 to 38.
By the way, this is where like the quality of your expert comes in. Can they be an absolute cockbag to the other side? Because they need to, but they need to do it professionally. And this guy's already doing that. He's showing well, what do you mean? Let's be precise. Why don't you try asking a better question?
8, let me just make sure I understand those pages. They are headed up with a heading that says courses, parentheses, instructed, designed, and authored, close parentheses. Am I correct in understanding that those pages contain the programs or seminars that you have either presented at or been the primary organizer of?
Well, I would say they highlight the ones that are, the short answer is yes, I've done those, but it's not a exclusive list, much as the same way my advisement on the cases or the first paragraph that you read referenced the listing of expert witness doesn't say that that's the only thing I've testified for. So I'd say it's a good list for highlighting.
So let me just, I focused on pages 33 to 38, and we'll get back to those in a second.
Okay.
But Dr. Black, maybe you can help me understand your CV and the way it's organized. I just want to make sure I'm up to speed on everything. Is there anywhere else in your CV where it would list potential trainings that you've done on civilian use of force other than pages 33 to 38?
No, not as a list. There's reference, like I said, and I've already answered, is that I would routinely do this as some of the things for my military mission, but I didn't list everything on that, nor would I normally do that. As for formal listings, I say 33 is a good page to start.
All right. Now, can you help me in those pages 33 to 38? Can you identify any of the trainings or seminars that you've done with regard to civilian use of force?
Yeah, sure. Well, now again, civilian use of force, meaning, well, okay, we'll just go for it. And then if I need clarification, I'm sure you'll ask. In the 2019 course, supervisor and that type of stuff, I'm looking on page 33. 2019 instruction for Deschutes County Sheriff's Office. There were civilians in the class, and part of the subject material covered would have been self-defense issues and the right of civilians to use force within certain things, so that police understand that as well as anybody else in the class did. Moving on down the list, Metro Academy was primarily police, staying on the same page. The Survival Skill Council chair and lead, we routinely taught civilians who oversaw within the committee the parameters of use of force to include civilian use of force parameters in addition to police, peace officers, corrections officers, and any differentiation between that. That would take you from 2017 through 2015.
The dark secret here is that police use of force and civilian use of force, when it comes down to justifiable use of deadly force, is actually really similar. It's really similar. The police get a little bit more leeway than civilians, but not much. And because the police's right to use deadly force is derived from an individual's right to use deadly force. The police just get the ability to use force to effect arrest for felonies in some states versus others. But the ultimate self-defense aspects of lethal force are not really different. The police officer has to make the same determination. Are they or is someone else in imminent danger of severe bodily harm or death? And would a reasonable person determine that utilizing deadly force would prevent that severe bodily harm or death? That's the question that cops have to ask and that civilians have to ask. And so all of this pussyfooting around, well, it's law enforcement's different. Not in these type of situations. If Kyle was a police officer who'd gotten separated from his unit rather than being Kyle Rittenhouse and had acted in the exact same way, the questions would be the exact same for the police officer as they were for Kyle Rittenhouse. Would a reasonable person armed with an AR-15 in that situation have acted in the way that Kyle did? If it was a cop or not a cop, the answers would be the same. So this is all nonsense.
With the same type of training. Moving to the next page. And again, these are, if you notice, from 2010 to 2013, or my listing there is 2006 to 2013. It's a highlight of what was taught. It is not every single class that was taught. Use of Force Review Committee, mentorship, lead instructors. We taught in the Civilian Police Academy on there, which I'm referred to as the Citizens Academy. So we not only taught citizens, taught reservists, but also taught the differentiation between self-defense, peace officer use of force, and the differentiation within the statutes and the understanding of self-defense regardless. Adult learning theory, and I'll just stop there since the next one is 2004.
All right, was that the end of the list?
No, I mean, I can keep going back, but that's 15 years in the past, unless you want me to go all the way back to 30 years.
Well, your list on page 38 begins, it looks like, in the year 1998. Is that correct?
That's correct.
Okay. So let's go back all the way to that. You had left off in, I guess, 2006. Let's keep going, and I want to make sure I'm not missing anything in those earlier years.
Yeah, no worries.
In the living years.
Not listed. I'm on page 34 now. The note there for deployed for the military, that would probably be the time frame I would have done some security training for both civilians and police agencies, upcoming police agencies. I want to say more likely than not, it probably was for Bosnia. I think that's right. I'm on to the next page now. Washington County annual patrol training, use of force updates would have included the Reserve Academy, Civilian Academy, which is listed there, which is instruction to citizens and civilians to include all aspects of whether it is a civilian use of force in defense of property, use of force in defense of person, all the other different issues. 2002.
I love that the prosecutor's just getting cucked right now because he's trying to show that this guy only knows about police use of force. He's like, have you ever even trained a civilian? He's like, okay, I mean, I'll tell you about all the times it's written in there, civilian, and he's just getting to lay out the fact that he's trained probably hundreds upon hundreds of civilians on use of force.
Same cross training occurring there. reserve academies, civilian academies, instructors of instructors type academies.
Dr. Black, could you, for the court reporter's benefit, could you slow down a little bit, please?
Absolutely,
Slow
my apologies.
down.
Thank you.
Kill me.
2001, again, deployments. Depending on where I was at, there would be some training overseas. Same type of training, reserve academies, civilian academies, regular academies, the differentiation between self-defense, the concepts, use of force in defense of yourself, defense of property, defense of person, defense of another. And then there was, and I don't see it listed here, but I was the primary representative to the Washington County Human Rights Council. And I did, as part of my instruction there, help them understand use of force at a, they oversaw basically, they were diversity inclusion efforts, still are today, and understanding how from different countries, how the perception of force at a civilian level is done. And that would bring us back to your point of 1998.
Okay, thank you very much. You have a doctorate from Capella University in Minnesota, is that correct?
Yes, sir.
And that was from the School of Business and Management, is that right?
Actually, yeah, I'm not sure of the exact title, but the School of Business was the common reference.
What was your focus of your dissertation?
Intelligence, but formally how people take visual information, in this case, visualizations, but visual information with the moderator or mediator being critical thinking and apply it forward into a decision process.
You already answered
Is your
this question.
dissertation published?
Yes, sir.
Is that something that is accessible on the internet?
Absolutely is.
Can you imagine that they haven't pulled his dissertation yet? This prosecutor hasn't pulled this guy's dissertation. They've known about this guy for months, and they haven't pulled it yet. Like, this is like this. Okay, you have to understand. This is the prosecutor's shot to be governor of Wisconsin. Like, this is your shot. This is where you go from, I'm a county prosecutor in the middle of nowhere, Wisconsin, to launching my career in politics, to governor, to senator, to whatever you want to be. If he can nail Kyle Rittenhouse, he has a stepping stone to whatever public office he wants. I mean, frankly, that's how prosecutors work. They wait their whole lives hoping for a case like this, because, and if they can nail it, they go on to do whatever. This case would, it would ignite the left behind this guy. He'd get to run as a Democrat in any case, and he'd have a really good shot at winning. And you haven't pulled this guy's dissertation. You've known this guy for months. Like, the amount of work that they're not doing is embarrassing. Again, it's the same with Bob. Like, Bob's report isn't even done yet. The reports were due back in August. They were due back in August, and Bob's report isn't done yet. They've had this case for over a year. Ray Fernandez says, Nick, is there hidden lore between judge and the prosecutor? I feel like the judge isn't a fan of him. I mean, no, I don't know anything about that. The prosecutors probably sat before this judge on numerous occasions for different cases. The prosecutors get this weird relationship with judges because they work with them every day. Hearing dozens of little hearings in all sorts of matters. Now, that might just be the judge trying to keep a professional distance. I think that prosecutors and judges have an incestuous relationship. They're both paid by the state, and their offices tend to be in the same buildings, even down the hallway. They see each other with frequency. I don't actually like it, but I don't know how you get around it either.
Have you ever testified in a court in the state of Wisconsin?
No, sir.
Have you ever consulted on any case in the state of Wisconsin?
Not that I can recall.
I want to turn to your report, which summarizes your opinion in this case. I believe that is Exhibit 1.
Correct.
Do you have that in front of you, Dr. Black?
I do, sir.
The first page of that report is entitled Expert Witness Preliminary Report, dated July 31st, 2021. Is that correct?
Yes, sir.
Is this the only report that you have generated in this case?
Yes, sir.
It indicates that it is a preliminary report. Why does it say that?
When I got it, it was, let me rephrase that. When I was receiving the evidence, due to the time compression of getting the report in, I knew that maybe some evidence may be arriving later, so to speak. And so,
Like maybe the prosecution's withheld FBI drone footage, you fucking cowards. God, these prosecutors suck. They just suck sometimes. And this guy is king of sucking. Stephen Cooper says the prosecutor is showing us Bob Ware's vagine.
so knowing that, I basically made this as a preliminary report, thinking that there may be additional, anything from deposition interviews, things that could give me a little bit more insight into the perception of the individuals involved as compared to just the level of video.
Since you prepared this report, have you received any additional evidence?
I would have to take a look within my files. The short answer is I don't know. I've received files. I'd have to examine them to see the dates, timestamps on them if they came in after July 31st.
Do you know whether or not you have actually reviewed any of that information?
If I received it, I would have reviewed it. I would have added it to the input ACE file or something else. Again, I'd have to go look at the timestamps.
Are you able to tell us today whether or not any of that new information that came in since the date of your report has changed your opinions in this case in any way?
No, I can accurately say any evidence that I've reviewed up to this point that's been given to me, the preliminary report that I've given, I see no reason to alter its conclusion. That I may change a couple words to make the arguments a little bit more easy to read, but the main content of it, I haven't changed that.
One of the things that you talk about in your report is the time span of these various shootings, and you testified earlier the methods that you use to measure the gap between the shots that were fired by Mr. Rittenhouse. Is that correct?
Yes, I testified to that earlier.
Why is that important to your opinion?
It helps me, it gives context. It's a baseline. If I can understand the objective baseline, it helps me understand the other things and their reasonableness. If I know that the shots were a quarter of a second apart, but someone, when they're speaking to it, says it felt like it took a lifetime, or felt like it was really long, or felt like it was seconds, I begin to get insight into what may be going on in that person's decision making as compared to the objective timeline, which is borne out by the objective evidence.
In this particular case, do you have any information about how Mr. Rittenhouse perceived that time?
I do not.
So other than what you've just described, is there any other reason why the time span of the shots is important to your opinion?
Well, the other thing it speaks, well, there's a myriad of reasons, but
it's you have to have a scientific basis to offer expert testimony. You fucking disingenuous pile of trash.
it's a baseline of investigation is to get the objective frame. Time, if we can determine it, is an objective frame. From that, I can take a look at many other things. Could a person have performed differently in the time that was actually present in the situation, regardless of what they felt, what they believed, or anything else? Can a person run X amount of feet within a certain time? Can a person do these things? The relationship of that is time-based. And so I, as a matter of just what I call sound practice, I try to get the timings done fairly early in the investigation as a way of giving myself an objective frame.
So hypothetically, Dr. Black, if the gap between shots here was a longer period of time than what you measured, would that impact your opinion in any way?
It could, depending on the significance and what the word longer means. I mean, if it was half a second, a second and a half, just doubling up things for easy, then the idea that there could have been time, there might have been time for what we would call more deliberate decision-making, or the person perceived, or had the ability to perceive such a thing, those can enter into some of the analysis. Whereas when things are tightly compressed, we'll call it deliberate decision-making, is not usually the first type of decision-making technique that one would go to, whether it's at a conscious or below the level of awareness level.
I'm not doing a full
So
shot.
in other words,
but I will
Dr.
take a
Black,
drink.
the short time frame between shots here gives you some insight into how much deliberation the defendant was utilizing when he was making those shots.
It might. It could also, and I'll use the same example as two different ways. So using roughly a quarter of a second, and in Mr. Rittenhouse's case, in event one, there's approximately a quarter second between shots. That is indicative of a person that it could be. I'm not saying it is, but it could be indicative of a person that has made a decision to shoot and continues to shoot until the decision to not shoot. So the first decision was potentially deliberative or potentially being pushed back and overwhelmed. But the quickness of the things in between is a person pulling the trigger during those timeframes without necessarily deliberative type of decision-making occurring between each. Some might be able to, some might not, but it would lean me more towards that person is at a high state of arousal, whatever that may be, fear, anger, whatever, it really doesn't there, but a high state of arousal. And what they're doing is they're pulling the trigger as quickly as they can because of whatever they are perceiving.
So let's talk about that first encounter with Mr. Rosenbaum. Counsel had asked you a question about prior threats to kill Mr. Rittenhouse that had been made by Mr. Rosenbaum. Are you aware of that?
I'm not aware of the exact framing of it, but I'm aware of the context of that evening and that being part of the context. But I don't have. I'd have to look through my notes to find the exact. If you're asking.
Importantly, notice this is good. What John Black is going to do right now, or what he's doing right now, besides having a great pause face, is he's saying, yeah, I mean, I'm kind of aware of some comments that were made, but his analysis doesn't focus on those comments that were made. His expert opinion that Kyle acted reasonably in using self-defense doesn't rely on hearing Joseph Rosenbaum say something about killing Kyle or going back to prison or anything like that. Doesn't rely on that. Not at all. And so this is actually great. His analysis is just relying on the video. That's the scope of his expertise, and that is all that's necessary for this. You know, that's sprinkling little sprinkles on the icing, right?
Asking for the exact verbiage that constituted a threat.
No, I'm just saying, is your opinion taking into account their prior contacts that evening?
Oh, yeah.
Between
The
Mr.
prior
Rittenhouse and Mr.
context and the
Rosenbaum.
pursuit and everything else. Yes, it is.
I'm not just talking about the pursuit at the gas station at 63rd and Sheridan, the car source location 3. I'm talking about earlier in the evening at a different location. Does your opinion take that into account?
It does.
What effect, if any, does that have on your opinion?
Well, the short answer is it doesn't have a lot. I'm aware of it, and I keep that in the back of my mind as awareness, but I don't have Kyle Rittenhouse's statement or anything indicating the impact of that earlier encounter. So I'm aware of it, as I would be of any other piece of evidence. I'm not going to say that it causes a decision to occur one way or the other. I would argue I don't have the right to do such.
What is
Great
your
answer.
understanding of
Great
what
answer, by the way.
those prior interactions were between Mr. Rittenhouse and Mr. Rosenbaum?
Again, notice he's like, it doesn't, I mean, it's something that happened. It's not really that big of a deal. The big deal is the fact that he was chasing Kyle Rittenhouse in a parking lot. That's the big deal. These other statements are a small, tiny little portion that he barely even considers. I mean, he knows they happen, so of course they're part of it, but not anything significant. Prosecution has missed this bus.
Again, I can tell you when I look at them what I perceive as an individual. I can make a hazard or guess of reasonable certainty at what other people might perceive from the same type of interaction. And I think you actually already called it the concept of threat. As for what Kyle Rittenhouse was thinking, I'd have no insight to that.
Dr. Black, my question to you, and I'll restate it, was what is your understanding of the prior interactions between Mr. Rittenhouse and Mr. Rosenbaum? Can you answer that question?
Yeah, my understanding of it, the way I viewed it, is they were at odds with each other, obviously. And if you were looking at it, the idea of the interaction, some might look at it and call it threatening. Other people might look at it and call it a strong level of disagreement. It could be viewed multiple ways. It is not one that would normally occur in what we would call either peaceful or friends.
And again, Dr. Black, what is your understanding? How would you characterize that prior interaction? I'm not interested in what some people would say. I want to know what you would say.
I would characterize it basically potential aggressive stance is the terminology I would use at it.
By Mr. Rosenbaum towards Mr. Rittenhouse?
Yes.
Yeah.
And again,
yes,
we're talking about earlier in the evening, not at the car source location, car source 3 at 63rd and Sheridan. We're talking about earlier in the evening at a different location.
Right.
Are we understanding one another?
Well, I hope so. I mean.
Okay. I just want to make sure. Okay. So you have considered that.
This happens with attorneys. So this is part of the how it plays out, right? Like you do a bunch of prep work and you're like, okay, I've got this plan. I've got this script, right? I've planned my questions out. I know what information I want to get out of this person. I know how I want to go after this witness. I know what I want to do. And then you get there and like the witness, God damn it. The witness is, answers in a way that doesn't really give you what you're after. And so what Binger has not figured out is that this line of questioning isn't helping him. There's nothing good coming out of this line of questioning. John Black effectively just dodged it by saying, yeah, I don't really give a shit about what he said earlier. mean, he said that with more words and with less profanity, but he doesn't really care. That statement it's ancillary. It's almost an afterthought. He clearly has not incorporated that as a main driver for the actions that would follow. But this guy really wants to focus on it because Richards brought it up at the other hearing. And so since Richards brought it up, now he's got to be like, oh yeah, I got to make sure, because this must be a key part of their defense that they're using with their expert, but it's not. So he's stuck on script mode now, and he's going to follow this script and go back to it because he hasn't figured out, I should just drop this and move on to the next question because this isn't profitable. It happens to some attorneys, and it's, it's not the worst thing. It doesn't benefit him, but it's not going to hurt him in this hearing. But it's just, he's stuck. And it's a difference between litigators who really, really like do this prepared, scripted questioning type stuff. And on complex issues, that's a real value. But the adaptability, the ability to say, okay, this isn't actually helping me. In fact, it might be slightly hurting my argument here. I should probably drop it and move on to something else. That's what should be happening, but he can't.
And I forget the words you just used, a potential aggressive stance
behavior,
or something
stance,
like that.
body language, whatever you want to call it.
By Mr. Rosenbaum towards Mr. Rittenhouse, you have considered that when forming your opinion in the case. Is that fair to say?
I was aware of it while forming my opinion, yes.
Now, at the time that Mr. Rittenhouse shot and killed Joseph Rosenbaum, do you have an opinion as to whether or not the defendant, Mr. Rittenhouse, knew that Joseph Rosenbaum was unarmed?
No.
I don't.
You've watched the video, correct?
Oh, absolutely. I've dissected it.
And you would agree with me that it is a fact that Joseph Rosenbaum was actually unarmed at all times during his interactions with Mr. Rittenhouse, correct?
The investigations show that. Yes, I would agree with that.
Hold on 1 second.
Any evidence that I've been given shows that.
Hold on, doctor, stop.
I don't believe the question is specific as to time. If he's talking about in the parking lot at Car Source 3, that's one thing. If we're talking about earlier in the evening when he's going around with things in his hands, that's something else. So I don't think the question is correct as to time. It's vague.
Could Madam Court Reporter read back the question, please, Your Honor?
I keep waiting to hear Bob fart.
Your Honor, the question contains a time parameter.
Well, it does.
That's the objection. The question is subsumes that.
Well, then it's an incorrect question because it doesn't. He wasn't unarmed at all times.
You can. I don't know what the facts are.
Okay.
The
Answer that.
witness can answer if he feels that the question is misleading or is based upon unsound analysis. So go ahead, doctor. Are you?
Yeah, I'm still here, and I apologize, Your Honor.
Wait, stop. I'm going to stop again.
What a disaster. Courts, this is court, y'all. It's clunky and messy.
I'll make sure I talk into the microphone more.
It's fucking people involved.
I thought my voice was one of those ones that people could hear.
I can still remember your voice from... remember when that fellow
Yes,
You
Judge.
know what I'm talking about.
Belgramarius.
Is that what his name was?
Yes.
Yeah. That was quite a trial. Mr. Richards was spit upon by a defendant, and then he spit on the jury, too.
Oh.
But anyway.
Richards or the defendant?
This judge is so goddamn old. He has a story for everything.
Anyway.
He's like
Oh,
Cup
that
from
one.
You know what to
Transformers.
expect.
Anyway, let's get back. Why don't we start with a fresh question, and let's take it from there.
Dr. Black, let me take another stab at this. Would you agree with me that Joseph Rosenbaum was unarmed on the evening of August 25th, 2020?
Again, given the conversation, I want to just put some caveats on it. And the video that I saw in the moments, what you called the events preceding when they had the conversation and the engagement, and the video that I saw that I'll refer to as I think you're calling it Service 3 or something similar to that, Gas Station 3, other than the bag being thrown, which could be perceived as some sort of irritant or chemical or that type of stuff, other than his physical ability to inflict harm through fists, feet, or bodily weapons, he was not, that I saw, armed with anything else that would be considered a weapon, knife or otherwise. It does not mean he did have them or didn't. I did not see them within the evidence that I've received.
So therefore, your opinion with regard to the killing of Joseph Rosenbaum is that Kyle Rittenhouse was justified to protect himself by use of deadly force to prevent Joseph Rosenbaum from taking his gun and killing him with it. Does that accurately summarize your opinion with regard to the shooting of Joseph Rosenbaum?
No, it does not.
Can you explain to us why you believe that Mr. Rittenhouse was justified in using deadly force to kill Joseph Rosenbaum?
Again, look, the short answer is yes. The totality of the things combined, not the singular event. We have a person that was a continuous event. I'm going to call the term a continuous event from the moment of the pursuit within the parking lot depicted in the video. This person, Mr. Rosenbaum, threw something, continued to move forward and continued to close the gap. This is representative of aggressive type behaviors within the context of anything from fires, looting, darkness, whatever else is going on. He's also willing to do this against a person that has already displayed and has on display a lethal firearm. In other words, he's willing to engage, right, wrong, or indifferent, with physical force against something that could potentially kill him. This speaks to potential intentionality, or whatever we want to call it. As I close the distance, being Mr. Rosenbaum, there is a moment in time depicted within the video where several things seemingly happen, indicated by the movement of Mr. Rosenbaum's body, the back of his body. As they close the distance, his hands are coming out. He is reaching in the direction of and appears to have make contact or be within just the moments of making contact, again, reaching for the weapon in a narrowed space, in a area that's there against Mr. Rittenhouse, engaging with him. Could it be just a physical altercation? It's possible. Could it be just he was going to try to take the weapon away and render it safe and then stop this from happening? Also possible. My analysis is it reasonable to perceive, would it be reasonable for a person to perceive that as this other person is potentially taking away the firearm, that as they do that, I will not have that mean to protect myself, and they will potentially use that against me. In all of those factors combined, I argue that it would be reasonable to use lethal force to defend against such a threat and a perception.
Absolutely.
So
Very
I want
well,
to narrow in on that, Dr.
well-crafted
Black.
answer.
the risk of great bodily harm or death to Kyle Rittenhouse from Joseph Rosenbaum specifically was that Joseph Rosenbaum would use Mr. Rittenhouse's gun against him. Is that correct?
That's
No.
part of it. He could easily have engaged in a physical altercation alongside of that.
Can you explain to us how Joseph Rosenbaum could have caused let me rephrase that. You're familiar with the jury instruction in the state of Wisconsin with regard to self-defense and the use of deadly force, correct?
I am. I've read it.
And that talks about defending against a substantial risk of death or great bodily harm to Mr. Rittenhouse, correct?
In the concept that he reasonably believes that it would be necessary to terminate such, yes.
So let's talk about what was the substantial risk of death or great bodily harm to Mr. Rittenhouse that was posed by Joseph Rosenbaum, okay?
Okay.
I asked you if it was simply Mr. Rittenhouse's gun, and you said no, it was more than that. So what other things was Joseph Rosenbaum doing to Mr.Rittenhouse that posed a substantial risk of death or great bodily harm?
He's just trying to hug him.
Right. And Counselor, I can appreciate the question, and I'm not trying to walk around it. You're absolutely correct. The crux of this, I would argue, or the primary weighting factor, is the fact that a firearm was involved. My argument is it is not as simple as that, and it's not taken out of context. If you were to ask me, and I was having a firearm slung across my body, and you were a friend of mine or anything else, can I see the gun? And I hand it over to you so that you can examine it. The distances are the same. The gun is the same, but the context is not. The intent, the willingness to do harm, and these type of things. In this case, I don't disagree. The gun is what raises it in my argument that a reasonable response, not the reasonable response, but a reasonable response is to use lethal force to protect oneself. In that vein, the reasonableness of it cannot be removed from the context of a person that is pursuing them, a person that has thrown something at them, a person that is cornering them in between things, and a person that continues to approach even though that other person, Mr. Rittenhouse, has a weapon. I'm not disagreeing that the crux of the reasonableness for lethal force rests on the fact that a firearm was present, but I'm also saying that it cannot be taken out of context.
So hypothetically, Dr. Black, if everything else in the situation was the same, except Mr. Rittenhouse did not have that gun, is it your opinion that Mr. Rittenhouse would have been reasonable and justified to use deadly force against Joseph Rosenbaum?
If Mr. Rittenhouse did not have the weapon.
There was no weapon present.
Right. And given all the other facts as seen, there wasn't any other big fighting or kick to the head, I would argue no.
Correct.
It wouldn't be a reasonable response.
I disagree. I think that's a bad answer.
Now, after that incident, you've
he mentioned earlier that he has hands and feet. He's got a willingness to inflict harm. He's confronting someone with a gun. It's a silly question to ask if, in the absence of the gun, if he'd be justified. I think he would be just as justified in using deadly force. He just wouldn't have the means to do it as simply. He would have to. He would be engaged in a fist fight, right? Like that would have been the difference. He would have been engaged in a physical altercation that might have turned out differently. So I think he should have headed off that question in that way. Mr. Obi-Wan 2020 says, able to tune in live. I'm getting burnt out with work. 12 hours a day, constant, and got Alaska PFD on Monday. So our early snow is going to get crazy for tires. People need to go get a fucking job, apply to places without mandates. There you go.
described how Mr. Rittenhouse travels up Sheridan Road, and you've described this crowd, and we move on to the other shootings. One of the clarifying questions I had for you was, Mr. Rittenhouse winds up tripping on his own feet and falling to the ground. No one actually pushes him to the ground or knocks him to the ground in the first place. Is that correct?
Probably so. Again, I'm not a expert on gait dynamics or anything else, but he was struck in the back of the head, knocking his hat off, and other people have been running and approach him. So it occurs within 2 steps of that event, a couple steps within that event. So it's not direct. It's not like the person got pushed down, but the idea of regaining your balance and stumbling as potentially related to that, there's a possibility. But the fact is he stumbles and he ends up on the ground, regardless of the cause.
And the first person who comes into contact with Mr. Rittenhouse after Mr. Rittenhouse falls to the ground is an African-American individual wearing a dark long-sleeve shirt, a mask, and some light-colored pants, correct?
Yes, light colored pants, dark top.
This is the individual who comes in and delivers some sort of flying kick to Mr. Rittenhouse's face or head area. Is that fair to say?
Head, neck, face area, but yes.
That individual does so with his own hands in his pockets, correct?
Yeah, it was weird as fuck.
I'd have to review the video frame by frame, but I know they were in there for at least part of it. I just can't say if they were there during the entire time.
At no point does that individual reach for Mr. Rittenhouse's gun, correct?
Not that I recall, no.
And Mr. Rittenhouse fires 2 shots at that individual from very close range and does not hit him, correct?
Correct.
Mr. Huber then comes in with his skateboard, and you characterize that situation as one in which Mr. Huber not only uses the skateboard against Mr. Rittenhouse, but also has his knees on top of him. You emphasize that point in your testimony. Is that correct?
Yes.
When you watch that video, would you agree with me that Mr. Huber's motions are primarily towards reaching for Mr. Rittenhouse's gun?
I would say that's probably, the short answer would be yes.
Would you agree with me that it does not appear that Mr. Huber intends to cause Mr. Rittenhouse physical harm with the skateboard?
No.
I would disagree with that. And it's not that I disagree with a binary conclusion that he intended to or not. I can't tell you what his intent was.
Would you agree with me that if indeed someone like Mr. Huber, hypothetically, had a skateboard and intended to use it to cause harm, they would hold it differently than what we see Mr. Huber holding it in this video, correct?
No, I would disagree with that. I haven't been trained in understanding how to use skateboards as a weapon, so I don't have a reference point. I can tell you how to use bats and other things as a weapon and other types of things. I'm not going to say whether the grip on the skateboard was indicative of whatever Mr. Huber's intent was.
One of the reasons why you've never been trained on how to use a skateboard as a weapon is because they're generally not used as weapons, correct?
Again, I haven't done any studies on the incident rate of skateboards as weapons, so I can't speak to that.
But you would agree with me that as Mr. Huber passes over Mr. Rittenhouse's body, Mr. Huber has a hold of Mr. Rittenhouse's gun, correct?
There was multiple times he was over his body, but yes, he did have a combination of, at one point, portions of the gun in the sling and then the gun itself.
And that was, you mentioned the sling. At all times during all of these shootings, Mr. Rittenhouse was wearing the weapon, a Smith & Wesson M&P 15 semi-automatic rifle attached to his body by a sling, correct?
The weapon was slung. It forms a type of attachment. It would seem that the sling shifted during that time. So I just, attachment, if the sling was in contact with his body and that would help it in retention. I don't know what attachment necessarily means.
With regard to
What was that sound?
Mr. Rittenhouse's shooting of Anthony Huber, is it your opinion that Mr. Rittenhouse, that it was reasonable for him to use deadly force to prevent Anthony Huber from taking the gun away and using it to kill Mr. Rittenhouse?
Well, again, I don't know what Anthony Huber's intent was, whether it was to kill Mr. Rittenhouse or not. I would argue back to your first point of the concept of reasonableness is a person had just struck me, whether it was an intentional attack or not, with a skateboard, using it as a weapon or not. I've been struck with a wooden object that moved, obviously, my balance. The same person has got now continuing, they didn't just run past me, they're continuing now to capitalize on that imbalance, try to remove the weapon from, in this case, acting as the reasonableness of a person being called Rittenhouse. And now they're, as you pointed out, jumping over or pulling away. And at that point, they are, at least it would be reasonable to believe by a person in that situation that person's trying to remove my weapon to take it from me. And then they would have control over the weapon, whether that control was to take it away or whether that control was to then use it and kill me right then and there. The reasonableness in my mind of the analysis is that a weapon taken from me would then and could then be used against me in a lethal manner.
If all of those circumstances regarding Anthony Huber and Mr. Rittenhouse are exactly the same, but Mr. Rittenhouse does not have a gun, there's no gun involved, would you agree with me that it would not have been reasonable for Mr. Rittenhouse to use deadly force to kill Anthony Huber?
I think that would be indicated more by what Mr. Huber's continued actions were. He could have still presented a future lethal threat by applying a chokehold or basically pounding a head into a pavement or something similar without the weapon being present. However, if everything else was exactly the same up into that moment of, just if I'm pulling, I don't know what I'm pulling on anymore. I'm pulling on his arm instead of the weapon as a hypothetical. If I was pulling on the arm, then not only I couldn't shoot him because I didn't have a gun and the gun wasn't there as a hypothetical, but I would not be applying lethal force for someone pulling on my arm. It's a hard hypothetical for me to fathom.
He should have done the same thing. It doesn't really matter what would have happened if there wasn't a gun there, because there was one, though. There was a gun. That's an immutable fact about the situation, is that a gun was present and was a strong factor in all of this. Peter Bemis says they're going to use the misdemeanor possession as a predicate for the instigating exception to self-defense. Yeah, I know they're going to try and do that, but they have to convict on that. And then the other problem they've got, though, is that Kyle did retreat. In all of the shootings, Kyle retreated first. So even as an instigating exception, he still followed his duty to retreat.
Sure. Maybe I didn't phrase it very well. Let me try again, Dr. Black. Let's look at it from the perspective of a substantial risk of great bodily harm or death.
Okay.
You'd agree with me that in that interaction between Mr. Rittenhouse and Mr. Huber, if everything else were the same except there were no gun, you'd agree with me that there was not a substantial risk of great bodily harm or death.
I wouldn't agree to this.
Correct?
No, I don't agree to it. He's got a skateboard.
Provided that the injuries or the construct of the physical stuff into the pavement if there wasn't anything from Mr. Huber's physical actions that could potentially damage the facial area, organs, eyes, mouth, hearing by being slammed into the pavement because of the body position of Rittenhouse, then yes, I would agree with that condition.
Just say no.
With regard to the final shooting of Gage Grosskreutz, you would agree with me that Mr. Rittenhouse used deadly force against Gage Grosskreutz, correct?
Correct, sir.
Obviously, Mr. Grosskreutz wasn't killed, but it doesn't change the fact that the defendant intended to kill him, correct?
That's incorrect. I don't know what the intent was of Mr. Rittenhouse. It's not indicated.
Can you help us understand, in your opinion, why Mr. Rittenhouse was justified or why it was reasonable for him to use deadly force against Mr. Grosskreutz?
Because he drew a gun on him?
Absolutely. And I think that's really a great question. It's the crux of the question. As you just stated, why would it be reasonable for Kyle Rittenhouse to believe that this person over there represented a potentially lethal threat? And this could be assailant 1, 2, or 3. It's the reasonable person in Kyle Rittenhouse's shoes looking outward through what he saw, his context, and his experience. And that's what I try to apply in that. So in the case of the third person, Mr. And I'll probably butcher the name, so I apologize, Grosskreutz, is that a couple things are very interesting in this one. First of all, is that Mr. Grosskreutz was approaching this scenario, this event, out of the fringes, and he sped up initially to get closer during the time when Mr. Huber was in an altercation with Mr. Rittenhouse. The round that goes off is, and the more importantly, I would argue, the muzzle flash from the shot against Mr. Huber is plainly visible within the frame and frames that Mr. Grosskreutz is seen approaching, moving, running towards Mr. Rittenhouse. So arguably, Mr. Grosskreutz knew, heard, saw indicators that Kyle Rittenhouse had fired his weapon. Mr. Huber leaves, disengages, I think is the term you used, and yet Mr. Grosskreutz continues to go forward, and that shot is what causes him to go back. You see him actually hunch down, recoil, and then move backwards. To me, the interesting thing about that is also within this frame, is within his right hand is plainly visible that would be purport to be a handgun and later determined to be a handgun. He raises his hand, handgun still in the hand. And at this point, Mr. Grosskreutz, for whatever reason, is seen moving forward again. But when he moves forward again, he actually loads, meaning that he like when you're bracing and you're about to push something, a car, a tackling dummy or whatever, you can see the stutter step and him loading, and then he comes back in. And so when he comes back in with that kind of behavior, you see the right arm coming down, and that's when you see that other muzzle flash that actually then ends up hitting him in the bicep. So it's, to me, what is significant is this idea of coming in initially, making a choice, Mr. Grosskreuz's choice, to then move backwards and then to re-engage again. And I think that is significant.
Is it your opinion that from those actions, Mr. Grosskreutz was lunging in to try and take Mr. Rittenhouse's weapon away?
He's drawing a
No,
firearm.
sir, because I'm not looking at the intent of Mr. Grosskreutz. I'm looking at the reasonableness of a person in Kyle Rittenhouse's shoes perception. Reframing that is that based on those actions, I would determine that it would be reasonable that Kyle Rittenhouse or a citizen in Kyle Rittenhouse's position perceive what you just stated. I can't speak to the intent of Mr. Grosskreutz, just like I can't speak to the intent of any other assailants that we've talked about today.
So let's take it from a different angle then. What actions did Mr. Grosskreutz take against Mr. Rittenhouse that would cause a substantial risk of death or great bodily harm to Mr.
He's got a
Rittenhouse?
fucking gun in his hand. He's drawing on him.
I can't answer the question in the way it's framed because for me, I analyze it by the actions that were potentially perceived, reasonably perceived. And again, I've already stated those. The willingness to re-engage, with a firearm in my right hand. The act of when the firearm is in my right hand is that once it's up, it begins to lower and come in my direction. Moving a firearm while I'm moving forward, a person, Mr. Grosskreutz, is moving forward, and then directing that firearm towards the direction of a person such as Mr. Rittenhouse could reasonably be perceived as a lethal threat.
You think?
Do you have your preliminary report in front of you, Dr. Black?
I do, sir.
I want to turn your attention to page 24 of your report. This is where you focus in on the interactions between Mr. Rittenhouse and Mr. Grosskreutz. And on page...
Like, just think about the shittiness of this prosecutor to suggest that Kyle merely carrying a gun is justification for everything that happened to him, right? The fact that he's got a gun is justification for all of the people attacking him. That's their theory. And to similarly then ignore the fact that Gage not only has a gun, but is drawing it at Kyle. He's like, well, what did he do to register a lethal threat? Like, the level of shitty disingenuousness required to hold those two conflicting positions is why everybody hates prosecutors the moment you run into one.
24, you have a number of paragraphs that are listed by Roman numeral, and one of them is Roman numeral or paragraph VII, paragraph 7. Do you see that?
Let me catch up with you. I'm sorry, did you say Roman numeral 7? It starts S3 is seen initially?
Yes.
Yes, I'm there, sir.
And your paragraph there describes the physical movements of Mr. Grosskreutz that you've also described here in your testimony. And then you say these are, and I'm quoting, these are indicators of someone that is about to either lunge or spring forward. Immediately after bracing his left foot, S3, subject 3, Mr. Grosskreutz, takes a significant step/lunge and moves towards K. Rittenhouse and could reasonably be perceived as attempting to assault, open parentheses, now with a firearm, close parentheses, or perhaps gain control of K. Rittenhouse's weapon. Did I read that correctly?
With the exception of one word off his left foot, but yes.
Oh, I'm sorry, I misread that. But otherwise, it's
no
all
worries.
correct?
Yes,
Okay.
sir.
So if I'm understanding you correctly, when you are trying to describe what Mr. Rittenhouse perceived in that moment, you believe it was reasonable for him to perceive Mr. Grosskreutz as either about to shoot him with Mr. Grosskreitz's gun or
Yes.
take away Mr. Rittenhouse's gun.
Yes.
That's
Is that fair to
incorrect.
say?
No, it's not.
Okay. Can you help us understand, in your expert opinion, what Mr. Rittenhouse's, what it would have been reasonable for him to perceive that Mr. Grosskreutz was going to do at the moment that Mr. Grosskreutz lunges or springs forward?
Right, and I think you just stated it correctly, at least in my mind, not meant any disrespect to you, is you stated correctly in your second half. It wasn't the same way you stated there. I'm not speaking to what Kyle Rittenhouse did perceive. I have no way of knowing that. I'm not speaking to what Mr. Grosskreitz's intent was. I have no way of knowing that. I have indications of that. At least he gave a statement, and we have that to go off of and weight that as we have. What I'm speaking to is a citizen in that position, given those indicators, would it be reasonable for them to believe that they were about to be assaulted? I would argue yes. That is one of the many reasonable things to perceive. They could also perceive that they wouldn't be assaulted. But I'm telling you that it would be reasonable to perceive, given those things, that they would be assaulted. Would it be reasonable to perceive, given everything else that had happened up to that point, given the fact that Huber had tried to take the weapon, given the fact that they're in a wrestling match, that this guy with a gun, Mr. Grosskreutz, was potentially coming in either with his gun or is going to try to take my gun? Would it be reasonable to perceive that? I would argue yes, that is one of many reasonable perceptions in that situation. Does that help?
It does. And just so we're clear, when you are describing the actions of Mr. Grosskreutz as posing a substantial risk of death or great bodily harm to Mr. Rittenhouse, this is what we're talking about, correct?
Almost. I've never described the actions in the terms that you used. What I described was it would be reasonable for Kyle Rittenhouse to perceive that they could be serious potential lead-ins, indicators, precursors to actions that would result in serious bodily harm and or death.
Okay. So just so I'm understanding you correctly, Dr. Black, your testimony, your opinion is that a reasonable person in Mr. Rittenhouse's position, seeing Gage Grosskreutz lunging towards him with that gun in his hand, the gun possibly lowering and pointing towards Mr. Rittenhouse, that it would be reasonable for Mr. Rittenhouse to believe that Mr. Grosskreutz posed a significant or substantial risk of death or great bodily harm in that moment.
Yes.
Correct. And within the context of just keep everything just like you said, and I would add to that, and within the context of a person that had been previously attacked twice, had a crowd surrounding him with weapons, had already been running and that kind of stuff. But just add in the context, and yes, I would agree with everything you said.
And to be even
just
more
pointing
precise,
a gun at him's enough.
a reasonable person in Mr. Rittenhouse's position at that point would be reasonable for them to perceive that the substantial risk of death or great bodily harm comes from either Mr. Grosskreutz shooting Mr. Grosskreutz's gun at Mr. Rittenhouse or Mr. Grosskreutz taking Mr. Rittenhouse's gun away and using it on Mr. Rittenhouse.
Or the entire crowd descending on him and using the wooden objects and bats and everything else they were running out of. But yeah, the short answer is those two would be indicator. But since we don't have Mr. Rittenhouse's perceptions at that time, the fact is any of those could be those being some of the obvious ones.
Dr. Black, are you suggesting that a reasonable person...
Are you suggesting, Dr. Black, that it's reasonable to perceive a threat when someone is pointing a gun at you? Jesus, this fucking dummy.
Mr. Rittenhouse's situation was entitled to shoot Mr. Grosskreutz to protect himself against threats posed by other people?
No, I didn't suggest that.
Okay. Now, if I'm understanding this situation with Mr. Grosskreutz correctly...
You're not, because you're an idiot.
We've talked about the threat of Mr. Grosskreuz's gun. Is the crux of that perceived threat the notion that Mr. Grosskreutz was pointing the gun at Mr. Rittenhouse?
It's part of it. The word crux being a singular thing, I would argue no. Again, to take everything out of context is it's not part of the reasonableness inquiry. We dissect it and we put it back in. Did pointing the gun have something to do with it? Absolutely. Did approaching and actually waving the gun have something to do with it? Absolutely. Did the fact that you approached him and then moved back to move back in have something to do with it? Absolutely. Whichever you want to call the crux, that's fine. I'm not going to argue for or against because all of them contributed.
No, he's got to consult the wide-body attorney.
I have no further questions, Your Honor.
Oh, thank Christ.
Going to Mr. Huber attacking Kyle Rittenhouse with the skateboard. A skateboard could be a deadly weapon, correct?
The ones I've seen, they're laminated wood, very, very strong. The same thing that they make shinais and other type of things in martial arts out of. They have metal wheels, and could they actually rip out an eye or break a neck? I would see. I mean, I could tell you that in my training, I could do it with a skateboard.
And so
I'd kill a man with a skateboard.
Is an object that could cause great bodily harm or death, is your testimony, correct?
Yes, sir.
And the real big issue in that would be the location of the strike, neck and head versus, say, to the body.
Yeah, I mean, a skateboard as an impact type of weapon, meaning it's generating force and then transferring that force into something, muscle tissue, bone, organ, whatever, is one, if I use the edge of the skateboard compared to the flat side of it, it's going to generate a lot more force. And if I strike you in the thigh with it compared to strike you within the neck or the head, that force then is going to be applied against something that isn't designed to take force. And so the edge of the skateboard, a wheel of a skateboard being swung in a centrifugal arc against the head and neck area, and also take into position here, a person in motion, just like a wind up, and then a person on the ground, which means that they don't have a lot of ways of getting out of the way, let alone not even looking in that direction. And they're being stabilized by the ground, meaning the force has a greater chance of being transferred from the swing into the tissue, the organs, the eyes, or whatever. So, yes.
And when Mr. Binger was going over your CV exhibit number 2 and saying,
he should have just said, haven't you even seen Gleaming the Cube? I mean, if you haven't seen Gleaming the Cube, how are you even an expert witness when there's a skateboard involved in causing damage to someone? Because if you haven't seen Gleaming the Cube, then you don't know that skateboards are fucking devastating. Especially when it's, Corey Haim, or was it Corey Feldman? Oh, fuck, I can't remember.
Saying they were in a law enforcement
Christian
setting.
Slater, damn
You
it.
testified for plaintiffs against law enforcement, correct?
Right. And and I apologize to the court if I misheard. What he said was where a law enforcement agency was present. That wasn't the fact that I testified for the law enforcement agency or I testified against a law enforcement agency. In a rough estimate, probably about 20% of the casework I do is actually against police agencies. And the reason being is I primarily do my work as a way of instituting change. So, yes.
And your opinions in this case are based upon factors that sometimes apply in law enforcement cases, but in this case, you're reviewing it from a citizen standpoint and their right to engage in self-defense.
From multiple things, the attention factors, the things we talk about, sense making, the things that I put within my report that are preamble, perception, attention, how we do that, those are human things. It doesn't matter whether you're a police officer, an Olympic athlete, or anything else. Some are better at it than others, but as a human organism, they are found throughout research in multiple things. Second to being a human is your training. In this case, police officers, and to the state's point, which I agree with, we add another layer on top of that type of analysis, rules and standards and training that's been applied and accepted practice and these type of things. But the overarching thing that's the same regardless is you're human first. After that, I take a look at the statutes, those that apply to a peace officer as compared to those that apply to a citizen, and I apply the appropriate standards based on their locale, their precedents against the case as well.
I have nothing further. Thank you, Doctor.
Any question?
No, Your Honor.
Thank you, Doctor.
Yes, sir.
Do you have more, Mr.?
I do not, Your Honor.
Let's take a break.
Your Honor, we had discussed with your clerk the possibility of conducting the hearing with regard to Mr. Willis at a later date after we've got his report. And we talked about the afternoon of October 25th, which I think works for all parties. So I don't know if it makes any sense to start with, today we'd be talking about his qualifications, which we can do, but it might be simpler just to do it all at the same time. I don't know what the court feels, but there's...
That would be fine with me, and you can...
Fine with me.
You can...
I didn't run that date past Mr. Willis. Mr. Willis, are you available on the afternoon of October 25th?
Let me check, and let me also add, I'm probably going to be kicked out of this building in 10 minutes.
Oh, well.
All the more reason to stop.
So would that afternoon work for you, Mr. Willis?
I'm checking right now.
What
Thank
kind
you.
of weird degenerate is this guy? Like,
That would be a Monday. Monday, the 25th of October. Believe it or not, I have a trial starting, guess where? In Kenosha. The Smith versus Bandy trial, but it's going to be day one. And I'm certain I would not be called on day one. So yes, I should be available.
2:15 works for us. Mr. Willis, does 2:15 that afternoon work for you then?
That'll be fine, and that'll be on Zoom again, correct?
Is that okay with you, Your Honor?
Well, if he's in Kenosha...
He lives in Wauwatosa. Would you be able to come down in person that day?
Oh, I didn't realize. Well, if he's going to be in Kenosha...
I'm not going to be in Kenosha. I'm just have a trial starting that day in Kenosha. I'm about an hour away in the Milwaukee area.
Okay, Zoom will be okay.
We can do it by Zoom, Mr. Willis. Thank you.
Okay.
All right.
What time?
Anything else?
2:15?
2:15, yes.
All
oh
right.
God, that's
Right.
going to be a chore to
Thank
get
you.
through.
Thank you. Enjoy the day.
Thank you.
Galaxy S9 waiting to come in.
Oh yeah, I'm not gonna play it out. There we go. That is gonna be one hell of a hearing. Imagine hearing that guy talk. Ugh. Ugh. So, there you go. There's the riveting Delbert hearing for an expert witness. I think Dr. Black is obviously qualified, upheld his testimony just fine. His testimony is definitely going to be valuable for a jury. That's fine. Bob is, I've said this a couple times, but I'll say it again. Bob is the prosecution's expert witness, and they'll be going through the exact same process there, qualifying him. He's their use of force expert. Even though they broke all the required timelines on this, they were supposed to have him, and he was supposed to turn in his report, I think, by August 21st, and they just didn't do it. And now he's going to turn his in on October 18th, and then they'll do his Delbert hearing on the 25th of October. So that is going to be a disaster. Talking to an emphysemic expert, we'll see. But no, I think John Black did very well here. He answered very carefully. His answers were consistent. That Kyle was reasonably justified in his actions based on all of the reasons given, based on the actual facts. The only answers I didn't really like of his were his answers to the weird hypotheticals that involved not having a gun. I think he should have just said, but there was a gun. There was a gun. We can't make a hypothetical where there is no gun and determine what the actions would have been in that situation. That's a silly question. So that's my only disagreement, and those aren't that big of a deal because those facts aren't part of the case, right? The fact is Kyle did have a gun. They were reaching for the gun. That seems to be indicated by the testimony or in the complaint. That seems to be indicated by the video. There's, and in Gage's case, of course, he drew a gun and was pointing it towards Kyle. And then, of course, with the other guy, the attempted murder is the guy, the jump kick bro, who has the wonderful jump kick to the head of Kyle Rittenhouse. Seems to be, again, getting kicked in the head is basically always considered an act of deadly force. So the idea that it's anything else is just absurd. But we'll see how it goes. We can only watch and see what happens in this crazy trial. Okay, I'm gonna read through super chats and wrap up the show. There will not be Twitch tonight. I still need some rest, and I really shouldn't have done this stream, but I wanted to get through this hearing, and yeah, tomorrow there will probably just be the one normal stream at night. We will not be doing double ups. It seemed like a good idea this afternoon. It did not seem like a good idea right before the show, and I'm about to drop. So, On Your Knees, B says, I saw a video years ago, pre-Snowden, where Shia LaBeouf back in 2008 admitted an FBI played audio recorded off a phone he made in 2006. Found video from 2008 on Jay Leno. There should be another clip from Conan pre-Snowden I cannot locate. I don't know what any of that means, but I believe you. I believe you. I didn't read this one out loud. I answered it in chat, but let me read it. Peter Bemis says, they are going to use the misdemeanor possession as a predicate for the instigating exception to self-defense. This seems to be a common theory that if Kyle was illegally possessing a rifle, that if he was guilty of this misdemeanor, that automatically means he has instigated violence, and therefore he's not justified in using deadly force. I mean, that might be their theory, but that is not a sound legal theory. That's not the definition of instigation. Instigation is an overt act. Just having a gun, even if it's a misdemeanor, is not an invitation to violence. I mean, if you think about other misdemeanor crimes like littering, like someone threw some paper on the ground, so suddenly you get to attack them, like you get to violently assault them. That's not how instigation works. He dropped apple cores on the ground. I guess he can't use self-defense now. Isn't how that happens. I mean, that it is a popular theory going around in Kyle's detractors right now. So it's a reasonable thought that that's what the prosecution's doing. It shouldn't work, is all I'm saying. Omega says, tell my wife Miranda happy birthday. She's 29, so we're getting old. Yeah, you are, but nowhere near as old as me. Wolfgang Deo says, I think we have to sit back, look at the socialist takeover, and laugh. We're on the right side of history, even if we may die by their hands. Flamethrower82 says, the old 90s rule, if you don't want the government to know, don't say it on an electronic line. Anti-Amina Libertatum says, learn a foreign language, search using that language, and then he sent some fucking gibberish in like Russian or whatever. Longreach Jones says, coming soon to Australia, self-isolation, the mobile game. Government sends isolating people a text. They have 5 minutes to take a photo next to their house, apartment number, or the government sends the COVID police. Yep, I saw this, and that is bullshit. I would never answer. I would make the cops come to my house every single time, and when they got there, I would I don't know. I'd have like someone shit all over them. Fuck them. Ishalson says Vic's case is the last of the 2019 cases that hasn't been stored now. If I read the site right, hashtag hopium. Maybe. I mean, maybe they'll decide it next. We don't know. Not applicable says, I mean ER instead of death by pneumonia. No, if I get to the point where I need to go to the ER, I will. I have an aversion to going to the ER because for some reason, like, my doctor doesn't want me to go into the fucking clinic. That's just stupid. Like, taking up an ER bed is a bit much. If I actually needed the emergency room, I'd go, but I'm not going to go there just because, because my doctor doesn't want me to go in. That's dumb. Mr. Lolnader says, what do you think? Pope a heretic for approving using aborted fetuses for all vaccines? I think so. Why am I wrong? I don't know that you're wrong. I'm not really here to argue the for or against this Pope. He's done some things I agree with and a lot of stuff that I don't. So Idea Machine says, let the goof flow you and your conversion to the lemon side will be complete. Longreach Jones says, easy access to cough syrup leads to excessive flaming mows. Very true. Not applicable says, ADE might be making it worse. So much for science. Ginger Ninja says, Bob doesn't get to share his expertise today. Takalutazaru says, hey, Nick, is Highland Park 12 as good as the 18 one? Well, no. I remember you giving the 18 one a 9, but it's expensive as fact. Can't find it under 100 pounds or 100 euros. No, it's still a good whiskey, but the Highland Park 18 is going to be a better, smoother whiskey than the 12 generally. But that doesn't mean you won't like it more. Older whiskeys tend to be smoother. I mean, that's the main thing that you're getting as the whiskeys get up in age. They tend to be smoother and have a more refined flavor. They tend to be a better representation. The older that they get, a better representation of what the I don't want to call him a brewmeister, but you know what I mean. The fucking still master wants. It's a better representation of the taste that they're going for. That's why those barrels of whiskey keep getting aged. They keep tasting the way that they want it to taste. Cars in Depth says, is there an expert witness who has measured how much an expert witness's testimony is affected by which party is paying him? Everybody knows. That's you hire an expert that will testify on your behalf. You don't hire an expert who won't. Tet says, does this goof realize he's not being graded on answer length? What a fart huffer. Holy crap. Nyotsu says, if a glowy glows in a glowy run and glowy attended event, does a glowy glow when there are no non-glows around? Yes. I like the Spike Man says, if you're watching an FPS game in 480 versus 4K, you'll hear and see everything at the exact same time. Video can't stop audio, and I'm sure there is someone who is studying the audio. Weird questions. DCV Titan says, it's not the dumbest toddler on the planet. Philip Booty says, who the fuck is Bob in the bottom left? Bob, again, is the prosecution's expert on use of force, who will testify on the 25th. Jackson Kai says, so rare to hear someone point out that biases are how we protect ourselves from danger. Kyle having a targeting bias for scum is a perfect example. Longreach Jones says, it is a tragedy. Need to clean a wood chipper after. Instant Ace says, Nick, if Kyle is found not guilty, could Bicep be gone, be charged with attempted first-degree murder? They're not going to charge them with anything. They could already charge him with attempted first-degree murder. They're not going to charge. They're not going to charge any of those people with anything because they're fucking cowards and they're dishonest. Q Mara says, when I was working a towing job last year, some of the dealerships in Kenosha were still dealing with people opening fire on them months after the riots. Kenosha ain't far either from the border. Mario Carter 13 says, Dr. Black sounds like Victor Davis Hanson. I don't know who that is. Fractal Machine says, upon further inspection, Kyle didn't get a perfect score because he didn't manage to shoot Dropkick Guy, unfortunately. Correct. CJ says, hey, person on the ground, I'm here to reach down and check your gender to determine what pronouns I need to address you. Rick Nikita says, jump kick man versus skateboard man. Casbiness says, no, Nick, everyone knows villains with guns always stupidly close the distance to their target. It's one of the things that allows the heroes to win. Yeah, it's weird, man. That's a weird fucking thing that they did. Chiquita Lokita says, how can I watch this in its entirety while sober? I want to take it in. You go back and look at the title and just plop the titles of those videos into YouTube. Search and it'll be the first ones. They're from the Long Crime YouTube channel. Joe B sent, Kyle's last shot was a bad shot. Changed my mind. too far off center. Yeah, well, I mean, he had to make it in a split second to not die. CJ says, sounds like West Virginia lawyer is a lemon disciple. He's not a lawyer. He's a use of force expert. Gun sluts. Ginger Ninja says, this performance is probably for the public audience watching. Bacon Man says, Nick, in your personal opinion, what implication will this case have in the future? In the case of self-defense from a crowd or just an individual case? I don't think it's going to have any precedential value because it should be just determined on basic self-defense principles, and Kyle should win. I don't really foresee some crazy appeal unless Kyle loses. Then there would be an appeal. But I can't. I mean, I can't foresee what implication the case would have. Mario Carter 13 says, I'd really prefer you be quiet. Something done quick. Clumsy K says, as a legal expert, is a prosecution attorney being a fucking douche? Yes. Yes. Jackson Kai says, Bob sitting in the back, well, he reads his credentials like, I'm not sure security guard at Chuck E. Cheese is going to cut it here. Mario Carter 13 says, some guy trying to nail Kyle is how we got here. Wick Dipper says, if you could wave a magic wand, what would you do to fix all the obvious problems with prosecutors? Well, I'd put souls back in them. Tom 7866. God damn. The cough syrup is wearing off. As this goes on, would Kyle be better served by having a trial by judge instead of jury? No. Considering that absolute idiocy of jury decisions lately. No. The reason you pick a jury over a judge is because you just need 1 in 12. You just need 1 out of 12. Where judge, you have to have 100%. Your odds are just better with a jury. Ginger Ninja says, can Dr. Black go back on this statement during trial? Can he bring up the possibility of striking wrestling by Rosenbaum at the time of the shooting? I mean, he can. Sure. I don't know that he'll need to, but he can. Mario Carter 13 says, skateboards aren't typically weapons. Neither are baseball bats. E fell. But hypothetically, if what happened went completely different in a different situation at a different time, would it still be reasonable to shoot? Yeah, I know. It was dumb questions, but he asked them. Aurora Uplink says, I just wanted to say I subscribed to be able to chat. Oh, thanks. Welcome. Welcome. It worked. It worked. Joel Reese says, can't wait to hear Bob. He's going to choke like Piper Perry on Black videos. Great show yesterday with Sargon. Hey, thank you. Deathwish says, you're still live, Rackets? I'm too sober right now. Send whiskey, SOS. Mandy Carvicius says, I'll be making fried chicken. Don't tell Drexel. God, I want fried chicken. Jackson Kai says, Bob, the hotel I'm at is by the hour, Your Honor. Ginger Ninja says, the state gets away with so much shit and breaking the protocols. How the justice system constantly allows this. Disgusting. Because it does. Because it does. Phantasmagorical says, it's officially my birthday. Take a shot of NyQuil for me. Happy birthday, Phantasmagorical. The NyQuil's upstairs. I'm going to take it as soon as this is over and go to sleep. No One Important says, hey, man, can you please do me a solid? Sent you via Twitter DMs. I need you to judge this person from 1 to 10, please. Chat can join too. Thank you. What? Judge this person from 1 to 10. What the hell is this? Oh, Jesus Christ. -50. Stop it. You know what? That was a shitty thing to do. Ace Brain 2003 says, here's my conspiracy theory. They want you to go to the ER so that you can be counted as a COVID hospitalization. Probably. Mr. Lolinator sent a donation. Thank you. Kay Bushelman says, my son gave me hand, foot, and mouth disease, but I couldn't go see my doctor because the symptoms match COVID symptoms. But I can wait 2 weeks for telehealth. F this. Yeah. Yep. And then finally, Mr. Lolinator says, how can the defense slip it into arguments that police have more training with way less threat to themselves and bring up this prosecutor's past? Well, the prosecutor's past won't be relevant to what Kyle did or didn't do. And neither actually is police training going to be necessarily relevant. I mean, they might make that argument, I guess, that police have shot with less justification, been fully justified in shooting, but I don't think they need to. I don't think they need to. It's Brianna Wu, guys. I'm not going to show it. No one needs to see that. No one needs to see Brianna Wu ever. Oh, Jesus. Okay, guys. That's the end of the show. I'm going to go try and breathe. I'm going to go try and breathe and go to sleep. Hope you guys have a good night. I'll play the outro and we'll see you tomorrow. Okay? Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an ardbeg, a bow, more of Lafroig. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. Oh, the guests are all plentiful, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who's